Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Saw a chicken fight.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihiangga kampo, he's Fairbanks Latino. I didn't ask you to interrupt me.
Is that correct?
Literally not true.
Oh, for Trump's sake.
Alrighty. Welcome back. Welcome to the Court of Public Opinion. I am the Recovery Addict.
You don't put a diplomatic plate on a hooch.
Right. That's what I was about to say the same thing. Here I am. Hello and welcome, Greeners. First in chat today, Greeners. You've been quiet, my friend. Hope you're doing okay. I know why you're quiet. You're fixing the internet for everybody. It's a busy job. And I happen to see your profile picture. It's just blank. Greeners, are you just feeling empty today? What happened? Hope you're doing okay. All right. Did anyone hear about the moose that attacked an ATM and then some random person stole $200,000 out of the money that fell out? A trained moose? I mean, yeah. Wow, that's interesting. Still would be theft. Just because it falls out of the ATM does not mean it's yours. So yeah, there's that.
I'm trying to have court. You don't raise your voice.
Oh, did everything show up on the screen properly? It did. Okay, good. I'm sorry I was a little bit late. My family just got home right now. Why is hello not working? Nothing is. I'm going to have to move these commands is what I'm going to need to do. I've got to move them from this drive to a different one. Big Dill just goes to sleep. I mean, like, now it should work again. It's just that simple. I just accessed it from File Explorer and it should work again. So
Hello.
There it is. All right.
I saw a chicken fight.
Mm-hmm.
Hello.
Yep. Does Stubby
Hello.
work?
Bring the jury.
Stubby didn't work. We'll see.
Not a camel.
We'll see. Stubby might work still. All right, we are we are a tiny bit late coming back, but so are they.
In the order that restrains you from talking to cats.
So are they. We're live. We did skip the jury instructions. There it worked, Grinder. We skipped the jury instruction discussion.
Hello.
Opting instead to just hear it one time as the judge reads it to the jury. Hello, welcome. Jade, long time no see. 16 months, Jade. Thank you very much for your support. I think it might be 2 p.m., so they got about 8 minutes. I think they were sent to lunch. They were going to be told by a bailiff what time to come back. So they probably got a little bit longer of a delay, a little bit longer lunch for the jury, which is good because they have some closing instructions to hear, and then we have closing arguments from both sides, which are going to be incredibly interesting, I think. Incredibly interesting.
Hello.
Let's see.
Hello.
Are they deliberating now? No, they haven't yet had the instructions or closing arguments
Don't
yet.
put a diplomatic plate on a hoopty.
Hush.
We only skipped the discussion that I'm going to turn these down for a minute. We only skipped the discussion the judge has with the attorneys about what they want in the jury instructions. If we get to 1,000, are you serious? Josh, did you? There's no way you said that. If we get to 1,000 hellos, Josh will gift 10 memberships. What was the result of our poll? 88% said guilty. And then the balance, the remaining 12%, some version of either not guilty or of guilty of being a bad dude only.
Hello.
There's no way, Josh. Hello. 1,000 hellos.
Hello.
Does that count as 2? As 1? when it says hello, hello.
Hello.
Who was saying hello? People are triggering a command.
Hello, hello.
That we clipped that command out of a Thurston County court proceeding.
Hello.
Where a Zoom participant was participating on the phone or on Zoom. I can't remember which one. And could not hear, but could be heard. And so he kept saying hello in the middle of the proceeding. It was really funny at the time. It's less so now. Less so now. Josh, where is Josh? Did he really say that?
Hello.
This is just Greeners. You're regretting that command now. I might turn the volume down on that one because I think it's at full volume compared to the other ones.
I think I'm about to catch a whooping.
To turn that one up to the same, then hello gets really loud. So probably have to turn it down just a bit.
Hush.
Oh, okay.
I'm trying to have court. Don't raise your voice again.
Hello.
We can do it while we wait, but once court starts, we'll stop.
Hello. No. Hello, hello.
All right. In fact, the hello guy is actually a cat.
Hello.
I think we have the I'm not a cat. We do.
I'm not a cat.
I'm not a camel.
Got those as well.
Hello.
Is it me you're looking for? That's a great response. Hello? I should put that on there. Greeners just gifted 10 memberships because he, in fact, lied about Josh, saying the Josh direct mailed the flyers and it said 1,000 hellos. Greeners, thank you very much for your generosity. And apology accepted. I'm pretty sure that's what this was. This was an apology. I'm gonna mute these for just a second. Let me just turn the hello down because I can. Hello. I'm sorry for crying hello in a crowded theater. Thank you, Greeners, for that. Give me a second. I'm gonna fix the hello volume so it's not so intrusive.
Hello, hello.
Yeah, I can hear it. Hello is down here at the bottom. I'm going to change the audio volume right to that. Then apply and refresh. Now it got quieter.
Hello.
Is that correct?
It's still a little loud.
Hello. Hello.
Cancel. Where am I at?
Front of the Walmart.
As we wait for the judge to come back, all they're doing is finalizing the instructions. It does take a while for the clerks to put them together and everything, but once those get finalized, I think we'll be ready for the jury to come out and for the judge to read everything. Okay, I'm just gonna mute them all the way for just a little bit. I just came back. Was there an apology to me? Why am I being apologized to? Josh, your name may have been slandered by someone, saying that you had said that if we sent this command 1,000 times, you would gift a bunch of memberships. Josh usually makes more sure bets that way. He usually hedges his bets a little bit. Like he says, if the Blue Jays win the World Series, obviously knowing that they were going to lose by a smidgen. And they did not win, so Josh, you're off the hook for that one. All right, where are we in this case? Let me tell you where I am personally, and it's this. Based on the evidence we get just at the scene of the crime, it is probable, it is possible, I would even say it's reasonable to conclude that it was a self-harm incident. But based on all the circumstantial evidence we see from the actions and the knowledge that the defendant has exhibited and shared before it was public knowledge, that becomes not reasonable for me. And Josh gifted 10 members. Did you do that, Josh? Did you actually say if you... I turned to hellos off, but that is awesome, Josh. Thank you very much for your generosity. Appreciate both of you. Miss Chris, 620, member for 29 months, makes you an OG. Hey, you, I've been MIA, but I'm back. Miss Chris, wonderful to have you back. Thank you very much. I love that pink courthouse by your name. Hope you're enjoying that as well. Josh is a man of his word. 10 memberships for my name being slandered by greeners. Slander away, greeners. No, just kidding. The totality of the overwhelming circumstantial evidence. Lizzie, yes, basically that's where I'm at, because it isn't a smoking gun case. Aside from, some really, how do you explain him having prior knowledge of who was dead in the woods and searching basically by name for the facts of the case, which were not publicly known and which were not aired over the scanner? They don't do that. How do you explain him knowing that and conveying that there are problems before he even finds out there are problems? He can't know that. It at least says that he had knowledge that she was dead there. And it just seems unreasonable that he was there while she did the self-harm and then just left and did nothing about it. All his other actions, everything together, I've gotten to the point where I can say I would be able to decide without hesitation to vote guilty in this case on this defendant. And it's not because he's a terrible dude and the awful things he did to Stephanie and how he treated her and the abuse and the, I'd say borderline torture that he put her through. It's not because of that. Take that out of the case and it's still not there. Did we see a photo of a woman on a trail cam during this case? We heard of a woman on a trail cam. Yes, Jennifer. But I think the date that happened didn't line up with when, and she was in like flip-flops or something, right? It didn't line up for when it was. And there's no evidence that she saw anything. He used her phone to talk to his new girl. Yeah. All right. 2:01 right now. We're expecting the court to get a little lively and a little more action starting about right now. What's holding you back, Detective Vids? The manner of death. Manner of death is important, and it's almost always there. It's almost always present in a case like this. But obviously, when there is no body, you might still have a murder. It's weird hearing my actual name, Jen Pookie.
Well, counsel and Mr. Pahl are present at this time, and we discussed the jury instructions. I gave the parties what hopefully will be the final version of the jury instructions, and I want to review finally what we're going to do in regards to jury instructions. So, Ms. Opper or Ms. Gordon, who's going to handle Ms. Opper, you acknowledge receipt of the instructions?
Yes, sir.
All right, and Mr. Galavis, you do as well, sir?
Yes, sir.
Okay, so what I'm going to do is we're going to go to each instruction. I'll give the number, and I'll ask for an okay from each side, or let me know if there's any problems or concerns. So 100, state?
Yes.
Defense?
Yes.
115, state?
Yes.
The cameraman's still sleeping.
Yes, sir.
10, state?
Yes.
Defense?
Yes, sir. Wait a second. Is this the paper one you gave us we're looking at?
Good. Okay, I'll take a step back. You ready, Mr. Galavis?
Yes, sir.
You have the paper instructions, right?
Yes, sir.
All right, let's start again, okay? So I think you were probably looking at the ones that were on the screen prior to that. Okay. So 100 state.
Yes.
Defense.
Yes.
115 state.
Yes.
Defense.
Yes.
1010 state.
Yes.
Defense.
Yes.
1194 state.
Yes.
Defense.
Yes.
This is faster just reading the section
Yes.
numbers
Defense.
instead of the entire instruction.
145 state.
Yes.
Defense.
Yes.
103 state.
Yes.
Defense.
Yes.
162 state.
Yes.
Defense.
Yes.
170 state.
Yes.
Defense.
Yes.
275 state.
Yes.
Defense.
Yes.
Love my grandkids. Thank you.
180
30
state.
months.
Yes.
Defense.
Yes.
OG.
157 state.
We are
Yes.
live.
Defense.
Yes.
155 state.
Yes.
Defense.
Yes.
148 state.
Yes.
Defense.
Yes.
147 state.
Yes.
Defense.
Yes.
150 state.
Yes.
Defense.
Yes.
190 state.
Yes.
Defense.
Yes.
195 state.
Yes.
Defense.
Yes.
300 state.
Yes.
Defense.
Yes.
315 as to the form state.
Yes.
As to its inclusion and form. Defense.
Yes.
All right.
Wow.
200 state.
Yes.
Defense.
Pamela Weisenbach, 24
205
months.
state.
Yes.
Defense.
OG.
160 state.
Yes.
Defense.
Yes.
465 state.
Yes.
Defense.
Yes.
484 state.
Yes.
Defense.
Yes.
515 state.
Yes.
Defense.
Yes.
Now, 525 is the final instruction, the short form. We'll give each of you a copy of that as well. But obviously, that won't be read until and unless the jurors return with a verdict on each count. And we'll make a copy of that. Now, what about the verdicts from the state?
The verdicts are agreeable, Your Honor.
1 second. Okay. The original verdicts read dated this blank day of November 4, 2025. So there was an error there. So the ones that I'm going to use, you have the wrong ones, are going to say dated this blank day of November 2025. And then you're going to get a copy of 525 now.
Okay.
So again, the verdicts, instead of saying, putting the number 4 in, are going to be not guilty of first-degree intentional homicide, guilty of first-degree intentional homicide, guilty of hiding a corpse, and not guilty of hiding a corpse. And the presiding juror will fill in the dates.
No lesser included.
So 525 state.
Agreeable.
Defense.
Yes, sir.
Okay, and the verdict forms again from the state with that change, no allowing the jurors to fill in the date number. You're okay, state?
Yes.
And defense.
Yes, sir.
Okay, very good. Any additions or modifications from the state?
Nothing further, sir. Thank you.
All right. Any additions or modifications to the instructions from the defense?
No, sir.
Okay.
All right, we're ready
then,
to go forward.
With that, then our intent, as I indicated, I'll read up to the end of 160, and then you'll make your closing arguments, and then we'll select the alternates and send the jurors to deliberate. All right? So we'll wait. I'll see if all jurors are present. We can start early. They're all present. Any reason why we shouldn't start up now?
I don't know if there's more family expected. Is there anybody else?
Probably in the bathroom.
Okay. Can you just check the hallway, please, Detective Fredericks?
Detective Fitz, thanks for gifting
Other
membership.
than family
Other than
members
that,
coming in,
yes.
I think it'll be a couple minutes before we get the jurors in here. In
Sure.
any event. Anything else in Ms. Gordon, you're doing the closing?
Yes, sir.
And Mr. Wolf, you're doing the closing, right?
Yes, Your Honor.
Anything, Mr. Wolf, before we bring him back?
No, Your Honor.
Okay, let's do it.
Okay, thank you.
Let's do it. Donna Littlefield, thanks for gifting 5 memberships. Super generous. So Sue is not giving the closing here. It's going to be Miss Littlefield. And the judge is ready to go. He's like, let's get this show on the road. He started a membership training because he slandered you. Thank you to all those who gifted memberships. You guys are incredibly generous, and thanks for welcoming people with gifted memberships.
Okay, have a seat, everybody. Thank you very much. All 14 jurors have returned. Maybe this is the first time I got it right and got you back earlier than I thought, ladies and gentlemen. So, as I said, here's what's going to happen. I am going to read some closing instructions. I'll read the majority of the instructions. The attorneys will make closing statements. There's just a few final instructions after that. And then we're going to select those who will be the alternates. Again, I have no idea who it's going to be. And if you think I'm looking at one of you because I know you're wrong, right? It's going to be a random selection made by the computer, right? And I won't know until Mackenzie passes me that document later on in the course of the proceedings. Everybody please listen carefully. Even so, there may be a need to have one of the alternates return, right? I don't know. We'll see. But you'll get the instructions. You're going to have this book, this 3-ring binder that's going to contain the instructions that I'm going to read to you. And it's also going to have the verdict forms in it as well. If you have any questions, we'll talk about that, but I'll tell you now, if you have questions for us, there are forms in the back in the jury room that you would write the question out. The presiding juror would write the question out, knock on the door, give it to Mike, he'll bring it to us, and you'll get more instructions about that shortly. If you can't hear me, let me know, all right? I don't think that's going to happen, right? So, members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinions you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count in the information in this case charges that the defendant, Matthew E. Pahl, on or about Tuesday, August 23rd, 2022, in the town of Delafield, Waukesha County, Wisconsin, did cause the death of Stephanie Pavlons with intent to kill that person. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Here's the statutory definition of the crime. First-degree intentional homicide, as defined in 940.01 of the Criminal Code of Wisconsin, is committed by one that causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you, beyond a reasonable doubt, that the following two elements were present. Number one, the defendant caused the death of Stephanie Pavlons. Cause means that the defendant's act was a substantial factor in producing the death. Number two, the defendant acted with the intent to kill Stephanie Pavlons. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Stephanie Pavlons with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count on the information charges that the defendant, Matthew E. Pahl, on or about Tuesday, August 23rd, 2022, in the town of Delafield, Waukesha County, Wisconsin, did hide a corpse with the intent to conceal a crime. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The statutory definition of the crime. Section 940.11 sub 2 of the Criminal Code of Wisconsin is violated by one who hides a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements are present. Number one, the defendant hid a corpse. To hide means to put or keep out of sight. Number two, the defendant hid a corpse with intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from a fear to return a verdict of guilty is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant while it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. The district attorney and the defense have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. In this case, the district attorney and the defense have stipulated to the following facts. In the first stipulation that I read to you, on August 20, 2022, the rainfall in the Waukesha/Pewaukee area was 0.50 inches. On August 25th, 2022, the rainfall in the Waukesha-Pewaukee area was 1.39 inches. On August 28th to 29th, 2022, the rainfall in the Waukesha-Pewaukee area was 0.34 inches. There was no other rainfall in the Waukesha-Pewaukee area between August 15th to September 9th, 2022. In the second stipulation, The parties agreed as follows: that during the search, K-9 Raven exhibited 2 changes of behavior. That in his report, Deputy Willis stated that Detective LaFleur later confirmed the 2 vehicles K-9 Raven exhibited changes of behavior on were involved in fatalities. 3, that Attorney Galaviz became the attorney of record in this case at the beginning of April 2025. That at that time, no one in the Waukesha County Sheriff's Department or the Office of the District Attorney had a comprehensive list of the vehicles that were in the garage on September 19, 2022. Next, that counsel for the defense made an open records request to the Waukesha County Sheriff's Department. Next, that counsel for defense received reports related to the vehicles in the garage on September 19, 2022 from the Waukesha County Sheriff's Department. Next, that counsel prepared a summary which was substantially similar to Exhibit 610. That summary was provided to Ms. Pescador. Circumstantial evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented regarding other conduct of the defendant for which the defendant is not on trial. Specifically, evidence has been presented that the defendant committed acts of domestic violence against Stephanie Pavlons in 2020 and 2021. If you find that this conduct did occur, you should consider it only on the issues of motive, intent, preparation or plan, absence of mistake or accident, context or background. You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait, and that the defendant acted in conformity with that trait or character with respect to the offenses charged in this case. The evidence was received on the issues of motive, that is, whether the defendant has a reason to desire the result of the offense charged; intent, that is, whether the defendant acted with the state of mind that is required for the offense charged; preparation or plan, that is, whether the other conduct of the defendant was part of a design or scheme that led to the commission of the offense charged; absence of mistake or accident, that is, whether the defendant acted with the state of mind required for the offense charged; context or background, that is, to provide more complete presentation of the evidence relating to the offense charged. You may consider this evidence only for the purposes I have described, giving it the weight you determine it deserves. It is not to be used to conclude that the defendant is a bad person and for that reason is guilty of the offense charged. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine 3 things: whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. whether the statement was accurately restated here at trial, whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence in determining how much weight, if any, the statement delivers. Remarks of counsel are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received as evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. The weight of evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to be given to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other. Also, consider the qualifications and credibility of the witnesses and the facts supporting their opinions. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in a hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence, under the instructions given you by the court. Ladies and gentlemen, at this juncture, as I indicated, I've read most of the instructions. The attorneys will now give closing statements. The state, because they have the burden of proof, goes first, the defense second, and then the state will have an opportunity for a rebuttal closing if they wish. Ms. Gordon?
Thank you, Judge.
Please.
Ladies and gentlemen, I want to thank you for your time and your attention. I know it's been a long 7 days, jury selection, and then hearing a lot of tough, difficult evidence. I don't take that for granted, that it's hard for individuals off the street on your normal everyday life to hear some of the evidence that you've heard and seen, some of the photos that you've seen. So I appreciate the time and attention you've given to this case. In the state of Wisconsin versus Matthew Pahl, the state has to prove 2 elements on the charge of first-degree intentional homicide. We have to prove that the defendant caused the death of Stephanie Pavlon, meaning that the defendant's act was a substantial factor in producing her death, and that the defendant acted with the intent to kill Stephanie Pavlon. You heard from the medical examiner. She makes a medical determination. You, as the jurors, make a legal determination. Just because she was not able to determine a medical cause of death does not mean that you, as 12 jurors, cannot reach a conclusion that the state has proven beyond a reasonable doubt that the defendant caused Stephanie Pavlon's death. Because you have the benefit of all the evidence that you heard over the last few days. You heard the text messages, you saw the Skype messages, you saw the phone evidence, you saw the interviews, and you know the history between Mr. Matthew Pahl and his longtime girlfriend, Stephanie Pavlon. You have more evidence here today than Dr. Scheel was able to review. But also, you make an entirely different determination. I don't have to prove as the state that there was a motive or that this act was premeditated. I think in this case there was a motive. I think in this case Mr. Pahl was done with Stephanie Pavlon. But I don't have to prove that, and you don't have to believe that I've proven a motive beyond a reasonable doubt. This is a circumstantial case. You heard all the evidence, and particularly with Detective Schrader, all of the cell phone evidence. That is circumstantial evidence, but that is just as good as direct evidence. For count 2, I have to prove that the defendant hid a corpse, and to hide means to put or keep out of sight. and that the defendant hid a corpse with the intent to conceal a crime. The body must be concealed. It doesn't have to be buried. It doesn't have to be covered up. It just has to be concealed, out of sight. Ms. Pavlon's body was clearly concealed, clearly out of sight, because for 17 days, golfers at the Western Lakes Golf Club did not see her body. For 17 days, employees at OAW came and left every day. Some even ate their lunch on a picnic table looking out towards those woods, and they did not see her body. For 17 days, patients came and went from OAW and did not see her body. And you heard Deputy Frischello say, if that construction worker had not pointed the body out to me, I would not have been able to find it. Those construction workers just happened upon the body. They didn't intend to find the body. They didn't know that that's what they were going to find that day. Those poor construction workers were just trying to do their job, put in some no trespassing signs. But what they came upon was a nightmare. Ms. Pavlon's body was also not visible to the drivers on I-94 or to the drivers on Gulf Road. You had the opportunity to go out there and see the scene yourself. So use your common sense and judgment. That body was concealed. That body was hidden. And the defendant intended for her body to be concealed. He didn't want anyone to find her. He didn't want anyone to know what had happened. Sure, he didn't dig a grave and put her in a grave, but he didn't have to, because in 17 days, her body was so decomposed that Dr. Scheel couldn't determine a cause of death, that the insect activity and the state of decomposition was so great that he left us with very little evidence at the scene. Ladies and gentlemen, the defense asked a lot of questions about Ms. Pavlon's mental health history, her suicide attempts. But ladies and gentlemen, let's be clear. This was not a suicide. This is Stephanie Pavlon's, on August 18th, her conversations with Mr. Zakkos. Want to get together? You could come out to Delafield. We could get some dinner. Look at that picture of her. She looks happy. She looks upbeat. So how do we know this wasn't a suicide? She's making plans for her life. She's making plans with Mr. Zakkos, or at least trying to. She's telling her doctor that she wants to work on some problems that she might have with her memory. She wants to do some testing. She's concerned about her health. Someone that's not planning to live doesn't make those plans for their life. And Dr. Rushel told you she was more upbeat when he saw her in May. She was thinking more positively, and she was concerned about her future health problems. She wanted to find ways to make her life better. She was taking care of herself. Mrs. Pavlon's told you that Stephanie was looking forward to going to the Philippines. She was excited to get her passport. That was Stephanie's plan. That certainly wasn't Mr. Pahl's plan. He didn't want Stephanie to go with him, but Stephanie was excited about the future. You saw on her cell phone that she had upcoming appointments, both doctor's appointments. She had dentist appointments. You heard from the dental scheduler that said, yeah, I called her a couple of times because she was planning for the future. There are no suicide attempts since March of 2021. Was Stephanie depressed? Yeah, absolutely. You saw those journal entries. Her life was terrible. But who made her life terrible? Mr. Pahl. His violent and abusive actions made her life miserable. He controlled her medications. He controlled her movements. He controlled her finances. He controlled every aspect of her life. She doesn't even have the ability to take her medication when and how it's prescribed. No, Mr. Pahl tells her when she can have her medications. She has to ask him for her own medications. She has no prescriptions with her in the woods. She's found in the woods No purse, no water bottle, no drug paraphernalia, no prescriptions, nothing. Just a vape and a scalpel outside of the wooded area. The position of her body and the location of her body tell us this was not a suicide. Ms. Pavlons didn't go out there with the intention of ending her life. And finally, that note. The note that's found in Mr. Pahl's car, Exhibit 35. Mr. Pahl, initially in his interview, says that was just a cry for help. That's what him and his dad thought. But here in court, they characterized that as a suicide note. But ladies and gentlemen, that was no suicide note. That was a breakup note. That was an I'm done with you note. The content is not consistent with a suicide note. And where it's found, think about that. Under the floor car mat, under a piece of foam on the floor of the passenger footwell. If Stephanie is committing suicide on August 23rd, she surely isn't leaving a message for Mr. Pahl under a piece of foam under the floor mat. We also know that this isn't a medical cause of death. You heard from Dr. Reschel. How powerful was that testimony? He told you that there was a less than 1% chance that a seizure would cause great bodily harm or even death. He said the only times he could think of a seizure causing a patient's death was if they had the unlucky occasion to be swimming while they had the seizure. Or maybe they were sleeping and they smothered themselves in their bedding. This was not a seizure. You can rule that out. This was not a suicide. So what is this? This was a homicide. Mr. Pahl is covering his tracks from August 23rd all the way until he's arrested on September 18th of 2023. He says to his girlfriend in the Philippines, "We will be ready." On August 19th, we know that there's a conversation between Mr. Pahl and one of his girlfriends in the Philippines, Ms. Sherilyn Valente, saying he's upset that Sherilyn and Stephanie have been talking. He tells her, "I'm asking you just to leave her alone." He doesn't want them communicating. And why? Because they don't know that Stephanie's living with him. They don't know that Stephanie and Mr. Pahl have a child in common, Layla. They don't know that Stephanie is not his employee, that it's his girlfriend, his longtime partner. He's hoping for a future in the Philippines with a good, honest girlfriend. What he means by that? Someone that will obey him, do exactly what he tells them, and let him control every aspect of their life. He wants to move on. He wants to be in the Philippines, and that does not include Stephanie. So on August 23rd, we see Ms. Pavlons leaving the apartment at 8:39 a.m. Ladies and gentlemen, that is the last time Ms. Pavlons is ever seen entering, exiting that apartment. You saw her belongings. You watched that video over and over again. And I know we played it over and over again, but that video is so important because it tells us everything about Stephanie in her last moments of life. What is she wearing? What is she carrying? What does she have with her? On August 23rd, the defendant goes to his OAW appointment, and he takes this picture, captured at 9:34. It's pretty curious. Why are you taking a picture in your appointment? But also look at those windows. Those windows were pointed out by the defense a couple of times with a couple of different witnesses. Those windows at the top, you can't see anything out of those. You can't see into the wooded area. And those windows all the way to the other side of the building, there's all kinds of workout equipment. People are being rehabbed, having physical therapy. You can't see out those windows the way the defense wants you to believe. Then between 10:33, when Mr. Pahl's appointment is over, and 10:53 a.m., you saw these records. And these are so important, ladies and gentlemen, because they tell us
I was on the phone
that
with Mathis.
Mr. Pahl on the left and Ms. Pavlon's on the right, their cell phones are located at or near OAW for that entire time period. 20 minutes, that's plenty of time. That's plenty of time for Mr. Pahl to kill Ms. Pavlon's. There's 20 minutes that's unaccounted for. What is Mr. Pahl doing during that time? He says he's driving up and down the road looking for Ms. Pavlon's because she's just disappeared. That's not supported by the records. That's not supported by the records, and Ms. Pavlon's device was there too. Then from 10:54 to 11:03, you heard from Detective Schrader that both of those devices returned to the residence. At 11:03, you see Mr. Pahl's truck enter the Willow Park Apartments parking lot. Then, for about 11 minutes, Mr. Pahl is in the parking lot. In his truck? We don't know. There's no cameras that look out that direction, but we know he's not inside yet. At 11:14 a.m., the defendant comes in carrying Ms. Pavlon's pink water bottle. Between 11:14 and 12:19, just over an hour, the defendant is inside of his apartment. You should have noticed that on that last video, Mr. Pahl didn't prop the door open. In fact, on any day, August 23rd or after, he doesn't prop the door open for Ms. Pavlon's because he knows she's not coming back. He knows where she is. She's in the woods. She's dead. She's not coming back, so he doesn't need to leave the door open. At 12:19, he exits the apartments. He walks outside towards the parking lot, and from 12:19 to 12:29, he's again outside in that parking lot. We don't know what he's doing. But at 12:29, he comes in. And what is Mr. Pahl carrying? Mr. Pahl is carrying this purse, concealed in a bag. Concealed in a bag so that no one sees him coming in with this distinctive looking purse. Because Ms. Pavlon's was last seen walking out. And he's not stupid. He knows there's cameras. You saw him in some of those videos that Attorney Galvez showed you. He's kind of ducking his head, trying to stay out of the camera view when he's letting Stephanie in. He knows he's on camera. He has to conceal that. That is a vital piece of evidence. Ladies and gentlemen, you can see from this, that is absolutely Ms. Pavlon's purse that Mr. Pahl carries in that day. And he even tells law enforcement that he brought the purse back. He just lies about how that happened. Then on August 23rd, that afternoon, he makes 2 calls from Stephanie's phone. 2 calls to her food share card, checking her account. Why make those calls from her phone? According to him and what he tells law enforcement, he hasn't even found the phone yet. But we know that that's him using the phone. Mr. Pahl doesn't have visitors. Mr. Pahl and Ms. Pavlon's don't have friends. It's just the 2 of them. And if Ms. Pavlon's isn't there to make those calls, it's Mr. Pahl. Sorry. On August 24th, he then makes a call to Pick and Save Pharmacy. because he's going to pick up her prescription for alprazolam. He's also prescribed alprazolam, but he wants her alprazolam. Then on August 25th, he says, I'm really worried about somebody in my circle. 2 days have gone by. You saw no evidence that he called 911, said, oh my gosh, my girlfriend's missing. This is concerning. He doesn't call family members. No, he calls the pharmacy and he calls her food share. What is he really worried about? He's really worried that he's going to get caught because he killed Stephanie. He calls the Pick and Save pharmacy again on the 25th, and then he deletes that call. You should be asking yourselves, if he wasn't doing anything wrong, if Mr. Pahl had nothing to hide, why does he delete the call to Pick and Save pharmacy? If he was really just picking up her prescription because he was just being a good guy, then why delete the call? That day at 3:17, he picks up her prescription, which, important to note, that bottle's found at his apartment on September 17th. And guess what, ladies and gentlemen? It's empty. Stephanie Pavlons has not once been at that apartment to use her prescription. And yet, the prescription bottle is empty. He says that night to his friends in the Philippines, hoping something bad didn't happen, I'm getting even more worried. Yeah, I bet he's worried. It's been 2 days since Stephanie was last seen alive on camera. He knows she's dead. He knows that he could be in trouble. He even gets Stephanie gets a missed call from her daughter Layla on the 25th. He doesn't answer that Facebook call. He doesn't call Layla back. And again, he doesn't do anything. In fact, on that day, the defense showed you video of him sitting in the lobby, reading the newspaper, just going about his everyday life. Not the kind of guy that looks really worried about someone in his circle. He's really worried about himself. On August 26th, there's an email with Sherlyn Valente. He says, I think something bad happened here. Don't ask me through text. Over and over, he says, don't ask me through text. Something bad happened here. Like you murdered your girlfriend? That would be something bad. He says he woke up with a bad feeling. Yeah, a bad feeling that what he's doing is going to get him caught. His web history, he's searching for obituaries, searching Stephanie's name. Not a single soul in the world, except for Mr. Pahl, knows that Stephanie Pavlons is dead on August 26th. Not law enforcement, not Mr. and Mrs. Pavlons, not Layla Pavlons, Mr. Pahl. This is now 3 days after Stephanie is killed, and these messages about being worried, they just keep coming. Then on August 26th, Stephanie has 3 missed calls from Layla on Facebook. Then Layla calls her phone. She's so worried about her mom. Why aren't you answering the phone? She calls and calls and calls. And we know that 17 minutes later, Mr. Pahl listens to that voicemail. We know that. You can see from this evidence. Is this circumstantial? Absolutely. But it shows that it is Mr. Pahl that listens to that voicemail. Because what happens next? He says, my niece called, left message. She's in hospital and broke her leg. My God, what next? See, he didn't tell his girlfriends in the Philippines that he had a daughter with Stephanie, because maybe they wouldn't want to be with him. He's creating this fantasy life in the Philippines to escape his real life, his daughter, his longtime girlfriend, and he says Layla is his niece. But then there's all those bring to focus of the police scanner app. See, Mr. Pahl knows that Stephanie's isolated. He knows that she doesn't have any friends. He knows that she doesn't have anyone in her life that's going to be looking for her. Except for maybe Layla, except for maybe Mrs. Pavlons. and Mrs. Pavlons told you they'd go weeks without hearing from her. She's an adult. She's living with her boyfriend. It's not that uncommon. But she eventually comes back. She eventually comes and stays at their house. Mr. Pahl had a choice on August 25th and August 26th. If he was really worried about Stephanie, if she really just walked off the way he said she did, he could have picked up the phone and talked to Layla. He could have said, hey, I have Mom's phone here. I'm really worried. But that's not what he did. That's not what he did because he killed Stephanie. We also know that on August 26th, for the first time in over a month, or over 2 months, Mr. Matthew Pahl calls his dad Marvin Pahl. This is very suspicious. They haven't talked in a long time. They don't talk regularly, clearly. And then on August 27th, August 28th, they talk. 9/8, 9/9, 9/10, 9/11, 9/12, 9/13, 9/14, 9/15, and 9/17. He's calling his dad almost every day, repeatedly, and he's talking about his conversations with his girlfriends. So on August 27th, he calls his dad, and while he's on the phone with his dad, we know his dad is searching Stephanie Pavlons. Why is Marvin searching for Stephanie Pavlons? That's mighty suspicious. On August 28th, he says, I can't explain in text. See, if Stephanie's missing, or she killed herself, why can't he explain that in text? Ladies and gentlemen, the reasonable explanation here, he can't explain in text because he doesn't want to leave a trail. He thinks he's covering his trail. He thinks he's being smart about this. He's not texting about certain things. But he didn't know that we would know Stephanie's phone went to OAW and came back. He didn't know that we'd be able to look through her entire phone, find some things that he deleted. He didn't know that we were smarter than him because he thinks he's the smartest guy in the room. Ask yourself, why? Then on August 29th, he again searches obituaries, and this time Pavlons. Detective Schrader said he was conservative in how he listed these web histories. That each time he listed a web history, that was because it was a new and unique search, telling you that Mr. Pahl was making a new search for Miss Pavlons on August 29th. Again, no one in the world on August 29th, except for Mr. Pahl, knows that Stephanie Pavlons is deceased. Then this really weird exchange happens on September 4th. He poses as Stephanie. Mr. Pahl uses Stephanie's account to reach out to his girlfriend in the Philippines because they haven't been talking because he's been mad at her. He wants her back, but he's not going to be the one to reach out. So he reaches out through Stephanie's account. He sends her these messages, hey, what's happened with you and Matt? And then suddenly, Matt and Sherlyn start to talk again. On September 7th, he has this conversation. You had more than a year to be friends with Steph. Suddenly you act like a friend. She says, I'm sorry about Steph. She wasn't being a good friend, and to just leave it alone. He's mad. He's pretending to be mad because he doesn't want them to talk. But he knows, Mr. Pahl knows, Sherlyn wasn't talking to Stephanie. She was talking to Matt. And the day before, on September 6th, we know that he drives around the backside of OAW. You saw those really slowed dash cams as he comes around the back, just looking at that little wooded area where he left Miss Pavlon's body. He's looking to see if anyone found her, and on that day he goes to the car wash. He says that's the day he found the note. That's the day he found the purse. But the evidence suggests otherwise. Then on September 9th, he's supposed to go to OAW. He has another appointment, but when he gets there, he is not expecting to see the law enforcement presence that is there. He is so caught off guard. He is so surprised. You saw him on that dash cam. He's in the right lane of travel, and he's like, whoop, nope, not going in there. Definitely not going in there right now. Got to figure this out. Ooh, what should I do? Yeah, I should probably drive all the way down into a subdivision, turn around, get my wits about me. He's probably thinking, if I don't go to the appointment, that'll look really suspicious. I'll go there. I'll try and find out what they're doing. I'll try and get an eye on what's going on. He doesn't just make a quick U-turn either. He drives all the way down into that subdivision, all the way to the end, and then turns around.
Patricia, 25 months.
Panicked.
Oh, geez.
He knows why they're there. He's the only person in the world that knows whose body is laying in those woods. He knows why they're there. He knows what they're doing, and he knows the jig is up. If he's not careful, if he doesn't cover his tracks, if he doesn't act carefully over the next few days, he's going to be in big trouble. So while he's at his appointment, he checks the police scanner. He calls his dad. And when he drives into OAW on September 9th, these are zoomed in stills of that dash camera. Look back into the woods, ladies and gentlemen. You can't see any of those detectives that are working in the area where the body was found. You can't see anything. That body was concealed. Mr. Pahl on September 9th, when he drives in, he can't see what they're doing back there, but he knows. This just proves how concealed that area is. It's concealed in plain sight. It's concealed in a busy area, but everybody's busy. Everybody's focusing on their own day, their appointment, their job, their drive. How many times have you thought, man, I just got to work and I don't remember getting here? Because you're focused on your own day. The people at OAW couldn't see what Matt hid. After his appointment, you heard him on the scanner as he walks out. He's outside of OAW for a little bit before he gets in his car, and then he goes right to his dad's house, where he and his dad talk things over. He doesn't approach the cops. He doesn't say, oh my gosh, I'm so glad you guys are here. I've been so worried about my girlfriend. She walked away from my car here 17 days ago. I had no idea. I have no idea where she is. No. He drove away. He didn't talk to police. He talked to his dad. While he's at his dad's house, look at these web searches. Stephanie Pavilions, missing woman found dead. Does anyone know that Stephanie Pavlons has been found dead on September 9th? Well, Mr. Pahl. Mr. Pahl knows. Maybe Marvin, based on these searches. The police definitely don't know that day. Waukesha police scanner, news happening today in Waukesha. Again, missing woman found dead. Body found by construction worker, dead. These searches, they tell you that Mr. Pahl knew what happened to Stephanie. They tell you that he was the one responsible for what happened to Stephanie. Then on September 9th, you heard testimony that the only other time he used the elevator was when his dad came over to spend the night. They took the elevator up to his apartment on the 3rd floor, and his dad spends the night. Then on September 10th, in the morning, Mr. Pahl reads this article. Dead body found by construction crew in Delafield. And you heard over and over again the testimony that no one knew that this was a woman. On September 10th, we don't even know who the body is. We don't know who the identity of that person is. And then at 8:26 p.m., Mr. Marvin Pahl is searching Stephanie Pavlon's. On September 11th, he says he's wondering why all this bad shit now is grieving time. What are you grieving? You're grieving Stephanie because you killed her. Who's dead? No one knows that Stephanie's dead. Nobody but Mr. Pahl. He certainly doesn't seem like he's been grieving. He's been chatting daily with both of his girlfriends in the Philippines. He's going about his life. No huge change in pattern for Mr. Pahl. He's just going about his life, taking walks, taking her phone with him when he goes to appointments, random places out in the city of Waukesha. Who knows why he's doing that? But we know Stephanie Pavlon's isn't making that phone move. The only reasonable explanation is that Mr. Pahl was taking the phone. Then Mrs. Pavlon's calls Stephanie, her mom. Her mom calls her. And Mr. Pahl, her partner of 20 years, doesn't answer the phone and say, hey, Georgianne, I know things are really strained between us, but I'm worried. I haven't heard from her. I haven't seen her. I don't know what's going on with her. Have you seen her? Have you heard from her? No, he doesn't do that. Defense is going to say, well, he's just a bad boyfriend. He's a really bad boyfriend, and you don't have to like him, but, you know, it is what it is. That doesn't mean he killed her. If he didn't kill her, why doesn't he answer the phone? If he didn't kill her, why does he check the voicemail and then go on with his day? He then calls his dad at 6:36 p.m. And that night he says, I had a long talk with Dad. We will be ready. Ready for what? Ready for the police? Ready for the investigation that's going to follow? Ready for the search warrants that will happen? Ready for what? The family called someone and said nobody has seen her. The family. Mrs. Pavlon's. Because Mrs. Pavlon's called her that day. And Matt knows, Mr. Pahl knows, that the only people in her life that are actually going to raise some alarms or might be concerned about her are her mother and her father and her daughter. Then on September 12th, again, web searches for obituaries and funeral services. Now keep in mind, this is the day that Mr. and Mrs. Pavlon's learn that their daughter is deceased. They're notified on that day by Detective Fredericks and Detective Plennis. They make the death notification. And on that same day, Mr. Pahl, who has not been notified by law enforcement, is searching for her obituary. Mrs. Pavlon calls again that day. Mr. Pahl still doesn't answer. He deletes the call to the voicemail, and Marvin is checking CCAP and dead body found by construction worker. Dead body found in Delafield. September 14th, if you don't hear from me because something happens, I'll get with you ASAP. In case something bad happens, he says a lot of chatter about this and that, but nothing concrete, not texting anymore. This is a constant theme. He won't put it in text because he knows if he'd put it in text, I'd be reading it here, right here for you in court. He knows that. He's not that stupid. He knows he has to be careful. He can't text it followed by calls. What are they talking about on the calls? We're never going to know that.
Mrs. Ari said hi, but she just needed me to help her get a computer.
Then on September 15th, he says, driving back from Dad's, got my banking business done for overseas traveling. Says to the other girlfriend, Sherlyn, did banking business for overseas travel. Then he sends a message from Stephanie's phone to his phone. And this is the only remaining message between Stephanie and Mr. Pahl on her device. Some YouTube link, some article about ATF. I don't know what the significance of that is, but I do know the fact that that's the only remaining message means that Mr. Pahl had been very busy deleting things. And we know he was very busy deleting things because Detective Schrader explained this to you. 380 messages are deleted between March 17th and June 17th. 442 messages deleted between June 17th and August 15th. And 93 messages deleted between August 15th and September 14th. All kinds of things we know were deleted after September 8th because Detective Schrader testified about that snapshot that came up on her phone, that no one would be able to see, right? That he could look through her phone and find. And it had text messages and calls, all of which are deleted. That snapshot's taken on September 8th. So sometime between September 8th and September 17th, Mr. Pahl was deleting things. I don't know when he deleted all these messages. I don't know if he deleted these messages. But I do know that there are no messages between Stephanie and Mr. Pahl. That's pretty curious, given that they're so close. They spend so much time together. Why are all those messages gone? If Miss Pavlons is just missing, if she's just walked off, if she's committed suicide, why is he deleting things? Why is he deleting voicemails? He's covering his tracks. He will be ready. And 66 times he brings to focus the police scanner app on 9/9. Now, ladies and gentlemen, I've talked about all the cell phone evidence now that points to Mr. Pahl being guilty of this, of the state proving beyond a reasonable doubt, circumstantial evidence that Mr. Pahl was the person that caused the death of Stephanie Pavlons. I want to talk to you about that interview. I know that was a lot of days ago, and a lot has happened since then. But let's talk through some of those inconsistencies that he had in his interview. When he's asked about the phone, he gives a few different versions. First, he says, well, I found it when I found the purse, which is on September 6th when he's at the car wash. But then he says, no, she didn't have her phone that day. She left it at the apartment. Because I said, oh, I'll text you when I'm done with my appointment. And she said, oh, I left it at the apartment. See, but he didn't know that we could track her phone. He didn't know when he made that lie to the police that we had tracked her phone to OAW and back. So he got caught in a lie. And what does he do? Oh, well, I thought, maybe her mom picked her up. Well, how could you call her mom? Well, I couldn't call her because, she didn't have her phone because I had her phone. Right. He's trying to cover his tracks. He doesn't know what we know. So during the interview, he's constantly asking law enforcement, well, what do you know? Well, what did you see out there? What was going on in the woods? What were you guys doing yesterday? He's trying to gather information from them so he can weave his story together. And he weaves some truth in with the lies because he thinks that'll make it more believable. When he's asked about the purse, he says, well, I found it at the car wash. Before he knows he's caught in the lie, he says, yeah, it was the black purse. Yeah, that black purse, sure. Yeah, I brought that in. He's asked, well, how did you bring it in? He's like, well, it would look strange if I just, carried it on my shoulder. But he never answers the question directly. And then, when confronted, he says, oh, that's not the purse. That doesn't prove anything. That doesn't prove anything. Well, Mr. Pahl, it proves a lot of things. It proves that you knew Stephanie wasn't coming back. It proves you had the purse on August 23rd. Why did you have her purse on August 23rd? Then he says, oh, no. It was a different purse that I found on September 6th. It was a gray purse. Okay. The damage was already done. We'd already caught him in a lie. When he's asked about the note, He claims to have also found that at the car wash. And at one point even says, oh, well, you know, if I had found the note and the purse together, then I would have been really worried. I probably would have done something. I probably would have done something about that. Well, he didn't. He didn't do anything about that. He didn't find the purse and the note together at the car wash. You saw that video. He wasn't like, oh my God, a note. A note from Stephanie. I didn't know she left this. No. He takes the mats out. He hangs them up, comes back. He doesn't vacuum the car. He doesn't spray down the mats. He just takes them out and puts them back in. See, because here's where Mr. Pahl's deliberate. He knew there was video. He knew we were watching. He's trying to cover his tracks every day. Bit by bit, he's trying to create a narrative. He doesn't say it's a suicide note that day when he's interviewed. He doesn't say, yeah, I thought Stephanie tried to kill herself based on this note. That's not what he says. And he also doesn't tell law enforcement that it's going to be found under a piece of foam under his car mat. That was weird. He cannot remember the last time that he saw Stephanie. It's more than 20 minutes, maybe even more than 40 minutes into the interview before he finally nails down, well, I think we went mattress shopping the day before. Okay, well, what happened the next day? What happened the next day, Mr. Pahl? Yeah, I think I went to OAW. Yeah, I think she went with me, but I don't know. Did you stop anywhere? Yeah, I don't know. Oh, yeah, no, actually, when I came out of my appointment, she was just gone. Ladies and gentlemen, that makes absolutely no sense. He doesn't have a story that fits the evidence. He tried to cover his tracks. He tried to do things that he thought would be distracting to us, but we found the evidence. The cell phones changed the game. Throughout that interview, he's trying to control the narrative, say that this was suicide, bring up every time they try to ask, well, when was the last time you saw her? Oh, well, you know, she's really suicidal. Yeah, she's a basket case. She's got problems. Let me tell you about all her problems. He doesn't sound like someone that's worried about the well-being of his girlfriend. He doesn't sound like someone that's concerned that she might be deceased, because he knows what happened, and he's trying to spin a web of lies. We know that after this, he travels to the Philippines. He goes to be with his girlfriend in the Philippines, and he comes back. Why did he go to the Philippines? Well, maybe he went there to be with his girlfriends. Maybe he was hoping to move there, get away from this case. He hadn't been charged yet, avoid any charges, which is why that extradition note, that's what we've called it, the note that's found in his apartment saying, extradition yes, extradition no, that's why that's so significant. He's looking for countries where he can't be brought back here to face the justice that Stephanie Pavlons deserves. He's not the smartest criminal. He's not the stupidest criminal. I don't have to prove to you that he's extra smart or that he made dumb decisions. Some of the things that he did don't make sense. You might be thinking, well, if he did this, why wouldn't he just dump his phone in the river? Well, I don't know. But he did it. And we have that evidence. And the phone evidence is powerful. The phone evidence is circumstantial, but bit by bit, as Detective Schrader went through that timeline, the state built its case. And Ms. Opper in her opening asked you to be patient. And I know you all were patient with the state as we built our case. Because this isn't a case where we had an eyewitness. This isn't a case where we had the homicide on video. We had to do hard work to prove this case. Each piece of evidence builds on one another. No single piece of evidence is determinative in this case. But each piece shows you the kind of person that Mr. Matthew Pahl was, shows you the relationship that Stephanie Pavlons had with Mr. Pahl, and ultimately that Stephanie Pavlons met her demise on August 23rd because of the actions of the defendant. This is a circumstantial case, ladies and gentlemen. I ask that you carefully consider each of the pieces of evidence that were presented to you, that you look at all of the evidence in a whole, not close up, one by one, because it's each piece put together that shows beyond a reasonable doubt that Mr. Pahl is not only guilty of first-degree intentional homicide, but that he also intentionally concealed Stephanie's body. And because he did that, because she was concealed, she was eaten by insects, her body decomposed so greatly to the point that there was no DNA evidence, there's no cause of death, but that doesn't change the other evidence we have. So ladies and gentlemen, I'm asking that you find the defendant guilty of both counts 1 and 2. Thank you.
Thank you, Ms. Gordon. Mr. Wolf.
Looks like 48 minutes and 11 seconds
Just make sure
on the timer.
our side works.
I'm going to reset that and see how long it takes for the defense to make their argument.
Good afternoon. You, the jury, are now charged with trying to assemble the recipe for the charged offenses on August 23rd of 2022. You have certain major ingredients. We know that Matthew Pahl and Stephanie Pavlons had been in some type of relationship for well over 23 years. Again, they had an adult daughter, Layla, together. We know Stephanie and Matthew never married. They had an on-again, off-again relationship. Stephanie spent periods of time with Matthew, and she spent extended periods of time at her parents' home in Delafield. Her driver's license was for the Delafield home, and she listed the Delafield home to medical providers. We know in 20 and 21, Matthew communicated regularly with at least 2 girls in the Philippines. Stephanie was not only aware of this, but she also communicated with at least one and likely both of them. We know Matthew and Stephanie had medical issues, and both were taking prescription medication. We know Stephanie had a history of mental health issues, including suicide attempts. We know in the summer of 2022, Matthew broke his foot and needed to go through several months of physical therapy. And then we know Stephanie stayed at Matthew's apartment the night of August 22nd, 2023. The next morning, they left the apartment building and drove to Orthopedic Associates in the town of Delafield, and they stopped at Quick Trip on the way. Matthew attended his therapy appointment, then drove directly back to his apartment, and Stephanie was no longer with him. We know on the morning of September 9th of 2022, some workers were placing those no trespassing signs around that wooded area, and they located Stephanie Pavlon's body. Finally, we know the Waukesha County Medical Examiner cannot determine the cause or manner of death for Stephanie Pavlons. You as a jury have heard 7 days of testimony. You've heard from 28 witnesses and seen hundreds of exhibits. That testimony and that evidence does not provide the full picture, and they are not the necessary ingredients, and they are not sufficient for the crimes charged. I also would like to thank you as the jury. You've made sacrifices from work, you've made sacrifices from your family. This is not only your civic duty, but we all have a desire to see that justice and fairness are preserved. You've given Mr. Pahl the opportunity to have his day in court, and I believe we have demonstrated he is not guilty of these crimes. If you remember back to jury selection, the questions were meticulous, they were repetitive, and they were selective. And I want you to think about why. Why is because we wanted 12 people who could reason, we wanted 12 people who could listen carefully to the evidence, and we wanted 12 people who could apply common sense. Remember back to jury selection again that you promised to presume Mr. Pahl innocent. And again, he was innocent in the eyes of the law, and I hope and trust that you presented him innocent at the onset of this case. Finally, you promised to hold the government to the burden of proving Mr. Pahl guilty of these crimes beyond a reasonable doubt and to a moral certainty. And I call upon you to abide by that promise. You've all heard the phrase reasonable doubt. It's been mentioned in this and other trials. The judge will provide you a definition of it, and the state has the burden of proving each and every element beyond a reasonable doubt. Prosecutors, lawyers, and even police officers work within standards that are called burdens of proof. Burdens of proofs are levels of certainty as to whether a fact is true. Perhaps the lowest burden is a mere hunch or a suspicion. The next level would be reasonable suspicion. And reasonable suspicion is defined as having specific facts that a specific individual did something wrong. Reasonable suspicion is needed for a police officer to make an involuntary contact, like a traffic stop. Next would be probable cause. Probable cause is a reasonable amount of suspicion, supported by circumstances sufficiently strong to justify a person's belief that certain facts are probably true. Probable cause is needed to arrest an individual for a criminal act. Then there's preponderance of evidence, which would be the next burden, and this is a balance of probabilities. And it is met if there is more than a 50% chance a fact is true. This is a general standard in civil cases. The next burden is clear and convincing evidence, and this means that a fact is highly and substantially more probable to be true. Finally, we have your burden of proof. Proof that something is true beyond a reasonable doubt. Again, this is proof of something so convincing that you would be willing to rely upon it without hesitation in the most important aspects of your life. This is something you have been told, and there is no plausible reason to believe otherwise. A criminal conviction is something so important that our legal system requires the government to prove someone committed each and every element of each charged offense beyond a reasonable doubt. Again, Mr. Pahl is charged with 2 offenses. The judge read the jury instructions, which give you the specific elements. I ask you to please review those elements very carefully. Reasonable doubt does not require you have the exact measurements of every required ingredient. However, it does require at the end you have a proper cake. I'm comfortable that the government has not met its burden.
Did he say cake?
You need to sort through all the items in your pantry. See what is needed for the recipe. You need to focus on what relates to those events of August 23rd and how or if those ingredients even contribute to the proper recipe. Tragically, Miss Pavlon's body was found in the woods on September 9th. Mr. Pahl was the last person seen with her. The police interviewed Georgianne Pavlons, and they reviewed some surveillance video. They arrest Mr. Pahl. They search his apartment, his car. A week later, they interview Matthew and his family. They hold Matthew for 3.5 hours, then interview him for 2. But they have to release him. A year later, after spending hundreds, if not thousands of hours focusing on Matthew Pahl's movements and his electronic communications, they arrest him. They conduct yet another search of his apartment, and they charge Matthew Pahl with first-degree intentional homicide. But there is reasonable doubt. The state has pointed out that Matthew must be guilty because he appeared to know something between August 23rd and September 17th. Stephanie drove with him to that scheduled appointment at Orthopedic Associates on August 23rd. Stephanie spent much of her time otherwise at the family home in Delafield, so she had a safe place to stay. Stephanie received SSDI for income. She had support from her parents. They drove her, and she had electronics at the house. Though she left her phone in the truck, she could text, Skype, and email on iPads. Most of her calls and texts were actually with Matt. Stephanie had emotional issues, and she also kept to herself. When he came out of his scheduled appointment, Stephanie was no longer there. He drives around a bit, but the cell phone mapping shows he didn't go much more than 300 meters or about 1,000 feet from the area of the appointment. But he would give Stephanie her space. He went home, he brought her stuff up to the apartment, so it was there when she returned. Matthew goes about his life. He checks the mail, he reads the paper, he goes for a bike ride, and he follows his routine.
He gets her drugs.
A few days go by,
drugs.
And he starts to express concern. You saw that in his communications. As you heard, Matthew is private. And he is paranoid of the government. He is worried that if something happened to Stephanie, he will be blamed. Then comes September 9th. Matthew sees a large police presence right next to Orthopedic Associates, and that's where he last saw Stephanie. His concern and his paranoia are really going. By the clothing and longer hair, all present deputies, officers, and detectives are aware the body is that of a female. By the shoes, we know that at least one of the construction workers knew it was a woman. The police talk with, they conduct interviews with people on the scene, including OAW employees and onlookers during the 4 to 5 hours they are on scene. Matthew monitors police scanners. He Googles the newspaper for stories, and he skims obituaries. Personally, I don't find this behavior suspicious. If someone I knew was missing, I'd do the same thing. He is now very concerned about Stephanie's whereabouts and her condition.
But you wouldn't call
Matthew
anyone.
Has had contact with police before. His worry, his paranoia, concern for himself continues to grow. You are shown his interview from September 17th. Yes, he is evasive. Yes, he is paranoid. And yes, he does not recall some specifics. Keep in mind, this is 25 days after he last saw Stephanie. The Waukesha City Police Tactical Unit had burst into his apartment. His home is searched. He's arrested. He's taken back to the sheriff's department, placed in a holding room for 3.5 hours, then read his Miranda rights. Yet what does he do? Despite all that, he actually speaks to officers for 2 hours. Then he's released. Despite his paranoia, the government has taken issue that Matthew didn't report her missing. We know Stephanie and Matthew had this on-again, off-again relationship, and Stephanie spent the time at her family home in Delafield. She received her mail at the Delafield house, and again, she used that address for medical records. We know Stephanie had a spare phone, an older phone at the house. She had other electronics still at her parents' home. Georgianne Pavlons also said that after the move from West Avenue to Delafield Street, Stephanie kept most of her stuff at that house. Finally, we were told Stephanie was very private. It was not unusual for Stephanie to have periods of no contact. No one, no friends, not Layla, not Georgianne Pavlons, despite an unanswered text August 25th, and not Richard Pavlons. No one reported her missing. The government made issue of the fact that Matthew accessed and occasionally used some electronics and even social media for Stephanie. Matthew and Stephanie spent time together. They worked together. Matthew recently bought one of Stephanie's cell phones for her, and he paid the phone costs and the data costs for both of them. The state even showed us a Skype exchange between one of the girls from the Philippines and Stephanie's account shortly after August 23rd. Ms. DeCierto sent 20-plus messages to Stephanie's account. Matthew responded once, maybe twice, pretending to be Stephanie. He was fishing, trying to see what Ms. DeCierto thought of Matthew. Then we saw Matthew quickly revealed it was him by mentioning spanking. He ended his trickery quickly. The government took issue with the fact that some calls were deleted from Stephanie's phone and maybe some texts. They make a big deal that Matthew was using Stephanie's phone, sending Facebook messages and Skype messages. But you saw Matthew's interview. He didn't tell the police, hey, her phone's been used. She's sending messages. She must be alive and well. There was no trickery like that. I honestly don't know why he did what he did, but it certainly doesn't prove that Matthew killed Stephanie Pavlons. What about the alprazolam prescription that Matthew picked up for Stephanie on August 25th? We know that particular bottle was found empty 3 weeks later. It was mentioned by the state on September 17th. We also know that at that time, both Matthew and Stephanie were prescribed that medication. We know Matthew monitored Stephanie's prescriptions. We heard testimony that medication was often carried in their pockets. We know police thoroughly checked Matthew's apartment and his truck. We never heard if any alprazolam in the prescription bottle or otherwise was found anywhere else during those searches. Then there's the black purse. Again, Stephanie and Matthew were frequently in and out of the building, up and down the stairs, carrying shopping bags, water bottles, and stuff to and from the truck. At some point, Matthew brought the purse back into the apartment and placed it with Stephanie's other tan bag in the bedroom closet for her when she returned. Like the pill bottle, Stephanie's phone, like her iPad, like her pink water bottle, he didn't throw the purse in the garbage. He didn't hide it. He didn't destroy it. There's no evidence Matthew wiped out his email accounts or his Skype accounts, and he didn't delete the memory from his dashboard camera. Again, it does not appear Matthew threw anything out despite his interactions with the police. During the search warrant a year later, in September 2023, detectives located in a box that list and designations of countries which wouldn't cooperate with extradition. But we have no idea when or why that list was made. It clearly was no secret that Matthew Pahl communicated very regularly with those two women in the Philippines, Miss Valente and Miss DeCierto. We learned Stephanie communicated with both of them. Both Stephanie and Matthew were making plans to travel to the Philippines. Given the regular and open communication, this does not appear to have anything directly to do with the end of Stephanie's life. 7 months after he had been arrested, then released, we learned Matthew planned a trip to the Philippines in March of 2023. Despite his DNA being taken right before he left, thus knowing he was still a person of interest, Matthew Pahl returned to Waukesha as scheduled in June of 2023. The state has replied on the testimony of Deputy Willis of the Racine County Sheriff's Department. Deputy Willis is a handler for Raven, and they had gone through cadaver search training. We heard a lot about Deputy Willis and Raven's training. Most of the training involved actual human remains. Deputy Willis testified the NNDDA is voluntary. It's a voluntary membership, and he pays an annual fee. No specific education is required, and he's not even required to take training notes. He is tested or certified once a year or so, and was tested and certified by Ms. Corcoran, who is his regular trainer. Furthermore, we learned that Raven's, most of Raven's real life, that most real life actual searches involved searches for entire human cadavers, and in one case, a tooth. If an area law enforcement agent needed a dog to search an area to see if there were human remains, I would be the first to tell them to call Deputy Willis and Raven. However, there's a very big difference between operational efficiency and forensic reliability for a criminal trial. We heard from several lab technicians and other experts. We heard about the importance of blind testing, even double-blind testing. From certain experts, we heard words like statistical confirmation and certainty. We also heard in one certification test for the NNDDA that Deputy Willis and Raven had an 80% proficiency. And that was a test that included human remains. And that was acceptable for his certification under the NNDDA policies. Again, I'm not saying Raven isn't a valuable tool, but detection by Raven does not come close to the reliability and validity required under most all forensic standards. Let's talk about the search that occurred and the circumstances under which that search occurred on September 19th, 2022. We heard from Detective LaFleur. She was working in the ID Bureau and took initial custody of Mr. Pahl's Tacoma pickup truck. She directed the truck be placed in the pole barn for 2 days prior, and that was on September 17th. She said the pole barn or garage was pretty full. Though she was in charge of the inventory for that pole barn, she could not say where or what specific vehicles were in the garage on the date of the search. She was aware that there were at least 2 vehicles that were involved in fatal accidents. We learned there were many more, and she appeared to be unaware of those. We learned about the position of Mr. Pahl's truck during the search. It was parked alone at one end of the garage. Moreover, it was immediately at the starting point and thus the end point of the search. We also learned from Deputy Willis that human cadaver odor can transfer to containers and other items, even if they do not come in contact. So Mr. Pahl's truck spends 2 days in that pole barn. in the vicinity of numerous vehicles that had substantial, confirmed, dead human cadaver contact. At Deputy Willis's direction, Detective LaFleur even burped each door of Mr. Pahl's pickup truck, moving the air from within, but also around the pickup truck. She was not directed to burp any other vehicle, and even Deputy Willis stated this was a less than an ideal environment for a cadaver dog search. Then the search begins. Raven starts the search adjacent to Mr. Pahl's pickup truck with no change in behavior. We know Raven did not indicate on most of the vehicles that were actually involved in human fatality accidents, including numerous vehicles, motorcycles, and motorcycles. And Raven did not even exhibit a change of behavior in most all cases, nor did she provide an alert. Then we learned that when Raven was nearly back to the starting point, done with the search area, she turned around. Then Deputy Willis started walking away. Raven looked up at him, then walked back to the rear of the pickup, and Raven sat down and appeared to provide a formal alert. The dog walked past the pickup truck, then changed her behavior when she was just about back to that service door. This test was certainly not double-blind. The detectives were all aware of the target. The test wasn't single-blind. Deputy Willis was advised of the target. Again, why is this important? It's important because of increased likelihood of human cueing, either intentionally or more likely unintentional. Cueing by Deputy Willis and cueing by the deputies present. We were also told by several experts and detectives that preservation during evidence or evidence gathering is critical. And it's critical for documentation. It's critical in criminal cases when there is a need for review, for critical analysis. Deputy Willis even takes photos for his training notes. On September 19th, Deputy Willis and certainly the Waukesha County Sheriff's Department had the capacity to record that canine search. Video would have been best, photo would have been good, even especially to have an inventory of that, specific inventory and placement of cars in the garage. But we have neither. We have no way to review or evaluate what truly and accurately happened. Finally, we learn that the Waukesha County Sheriff's Department, or detectives, brought in the forensic experts from the Wisconsin State Crime Lab to process the truck. Not only was there no visible evidence of any relevant volatile human remains, they took countless swabs, including from the rear bed and bumper. The results showed signs that Matthew Pahl was in the front cab of the truck and I think the bed of the truck, but all other tests were negative. Finally, we have the biggest areas of reasonable doubt. We still have those three questions that I asked at the beginning of this case. Question 1, how did Stephanie get from the cab of Matt's truck several hundred feet in broad daylight to the small wooded area where she was found? Keep in mind that in August and September of 2022, the area appeared to be quite active. It was not yet posted no trespassing. It was not overgrown like you saw. You saw the pictures. The body was along a path in a moderately sized clearing near a fire pit or a burn barrel, not far from numerous beer cans. Even after workers posted those no trespassing signs, at least one person walked that trail through the woods. We saw that on the trail cam picture. Keep in mind, the area is bounded by a heavily traveled frontage road and interstate, a very busy health center, a golf course, and homes. Question 2, if Matt carried Stephanie into that wooded area, when would he have done that? Keep in mind, Matt was still dealing with his broken foot. Keep in mind the distance from that parking lot to the woods, the traffic, the sight lines along the east side of Orthopedic Associates. Keep in mind that the government has hundreds of hours of camera footage and cell phone mapping, cameras that capture every single time Matthew leaves or enters that apartment building. That door 4 camera that captures every single time Matthew's truck leaves and enters the apartment. Those comings and goings correlate to cell phone mapping. Other than a few scheduled daytime appointments, there is no evidence that Matthew ever went back to the area of Orthopedic Associates. Think about this. If Matthew Pahl somehow killed Stephanie, why didn't he flee? He didn't flee after August 23rd, 2022. He kept his appointments at Orthopedic Associates. He kept his routine. He didn't flee after being arrested September 17th of 2022. He also could have stayed in the Philippines, but he returned as scheduled to Waukesha in June of 2023. Finally, we have question 3, and that is, what proof does the government have that Stephanie was actually killed by another person? Could it have been suicide? Could it have been a medical issue? Now, we had Deputy Schrader's outline that took a good part of 2 days. After scouring days, perhaps weeks, of surveillance footage, thousands of emails, hundreds of Skype messages, and other cell phone data, he provided his PowerPoint presentation. That PowerPoint presentation not only very selectively picked which messages and data to show, he actually showed just select portions of many of those messages. Still, none of those 3 questions were answered. The government certainly wants Stephanie's death to be a homicide. They presented selective evidence to support their theory. However, there are countless theories, and those theories are not inconsistent with the testimony and the evidence. Again, members of the government said Stephanie was murdered in the woods. Then maybe Stephanie was murdered in the pickup truck, then somehow dragged to the woods. Keep in mind, family members said Stephanie liked to go for walks outside, especially if she wanted to smoke. Maybe Stephanie walked into the woods to vape and something happened. Keep in mind, Stephanie accidentally urinated in Matthew's truck during an appointment 2 weeks earlier. And we know Stephanie did not use the restroom at Quick Trip. Maybe Stephanie walked into the woods to use the restroom and something happened. Maybe Stephanie accidentally overdosed on her prescribed medication. Stephanie's own mother, Georgianne Pavlons, testified Stephanie talked about suicide. We learned Stephanie recently overdosed on her prescription medication. We also heard Stephanie had visible cuts on her wrists. We have Stephanie's journals, and we have the note that was found in Matthew's truck. Perhaps it was an intentional overdose. While admittedly not likely, Stephanie could have used that scalpel, but there's not necessarily evidence of that. All I'm doing is trying to express the number of things that could have happened that aren't inconsistent with the evidence. We also know, finally, that officers found that empty container of Stephanie's seizure medication at the family home in Delafield. And we heard Dr. Rochelle talk about the correlation between stressors and epileptic seizures. Perhaps Stephanie had a seizure or another medical event. We have our Waukesha County medical examiner, Dr. Shields' testimony. She examined the scene. She examined the clothing. She examined Stephanie. Excuse me. She examined the scene. She examined the clothing. She examined the body. After a year of investigating and testing, she provided her report. Though her initial impression was that Stephanie's life ended in those woods, she could not be certain where she died. She could not rule out strangulation or suffocation, though the hyoid bone was intact. She could not rule out stabbing or other sharp object injuries. She even said there were two small, or we even heard testimony that there were 2 small spots on Stephanie's shirt which tested positive for human blood. But there was not evidence of substantial blood loss or marks on the clothing, the skin, or the bones. She could not rule out an overdose or a medical death. She could not even rule out a car accident, though that's doubtful. Dr. Shields determined cause of death and manner of death was undetermined. This was affirmed by Dr. Truesdale, the state's death investigator, and this was affirmed by Dr. Hale. Again, there were thousands of emails and Skype messages, and the government picked some messages from 2021 and a few in early 2022 that demonstrate Matthew was unkind and at times downright mean towards Stephanie. This was especially true when he was discussing the misuse of her prescription medication. We also saw a few selections from Stephanie's journal, which were over a year prior to August of 2022. Matthew Pahl was private. Matthew Pahl was clearly paranoid. Matthew was at times less than kind, perhaps much less than kind, with women, in particular Stephanie Pavlon's. But being a bad boyfriend does not make him a murderer. In summer of 2022, we don't have any of those type of entries. We don't have those journal entries. Stephanie was freely and willingly going back and forth between the Delafield house and Matthew's apartment. Keep this in mind. Georgianne Pavlon's testified, and she stated that she was not worried about Stephanie's safety when she was with Matthew Pahl. All this testimony and all this evidence is your pantry full of ingredients. You have certain background facts, and those are like the items in the fridge. The government has tried their best to assemble the specific ingredients. They decided Matthew Pahl somehow killed Stephanie Pavlon's. They have selected evidence to fit that theory. I sincerely hope that over the 7 days of testimony, you took good notes so that you're clearly aware of what was actually testified to. The state has baked what they want to be a chocolate cake. It doesn't look right, and it doesn't taste right.
Let's warm up the oven.
You will have the right to review some of the evidence. If you want to see a video or picture or certain documents, you can ask. You can see the video of Matthew coming back to the Willow Park apartments after that appointment on August 23rd, 2022. No dirt, no sweat. He looks just like he does on any other day, and he acts just like he did on any other day. I do have a final note before I finish up. I assume at times during the trial and presentation of evidence, you observe Matthew Pahl talking to either Attorney Galaviz or I. I can tell you, he knows the evidence in this case probably better than me. I did not always like when he interrupted me,
That's not a good thing
but
to
he was
confess.
passionate, and he pointed out when evidence was inconsistent with the evidence. Think about it. If a trial defendant just sat quietly, people may make other assumptions. Matthew is fighting for his freedom. Ladies and gentlemen of the jury, you sit today in this case as 12 judges, 12 individuals who control the destiny of Matthew Pahl. You sit here today as the ultimate law enforcement officers. Please give this case your full attention, deliberation, and analysis. There is not proof beyond a reasonable doubt. Though there has been significant proof that Mr. Pahl is innocent, he doesn't have to prove that. He doesn't have to prove anything. However, given the evidence and testimony, the state certainly has not satisfied their burden of proof with respect to the crimes charged. I'm confident you will render verdicts that will be consistent with good common sense and logic and find Matthew Pahl not guilty. Thank you.
So 32 minutes for the defense, considerably shorter. The state's going to get a rebuttal as well.
Go ahead, then.
Ladies and gentlemen, this is a classic story of escalating domestic violence. We know that there was a history of domestic violence incidents between Mr. Pahl and Ms. Stephanie Pavlon's. And we know that largely from her journals, because Ms. Stephanie Pavlon kept those journals in 2020 and 2021. Unfortunately, we did not find a journal from 2022. So I don't know what was happening in Stephanie's life in 2022, but we do know that on July 6th of 2020, she writes, "I feel trapped." July 9th of 2020, sick of being called every name in the book, no purpose but to be abused, he's Dr. Jekyll and Mr. Hyde. On August 2nd of 2020, I'm afraid of Matt, but have nowhere to go. September 2nd of 2020, scared to death of him, have no one. October 7th, 2020, she has a blown eardrum, a black eye, and you heard testimony that she went and saw an ENT. October 29th, I'm going to end up 6 feet under. Those are just selections of different journal entries that Ms. Pavlon's made. We know that Mr. Pahl was abusive, controlling, and violent. And we know that Mrs. Pavlon said she knew this was an unhealthy relationship. She doesn't know these details. She doesn't know the 100% of what detectives testified we learned. She didn't see text messages. She didn't see Ms. Pavlon's journal entries. She had no idea the violence was this bad. But as we know in domestic violence cases, domestic violence goes unreported. Victims of domestic violence don't tell their closest friends and family. It's humiliating. It's embarrassing. It's terrifying. The most dangerous time for a victim is when they decide that they're ready to leave. We know that there are significant size differences between Mr. Matthew Pahl and Ms. Stephanie Pavlon's. She's tiny, petite, incredibly skinny. Mr. Pahl works out, he exercises regularly, he's healthy and fit and muscular. He's taller than her, he weighs more than her. Stephanie is Mr. Pahl's punching bag. Whenever he has a bad day, he makes sure she's going to have a bad day too. Because he's not going to suffer alone. He wants her to hurt worse than he hurts. She's at a size disadvantage. She's scared to death of him. She can't fight back. He's bigger than her. He's stronger than her. He always gets his way. We don't know what fights are happening closer to August of 2022. There's no text messages between them. Wonder why. Ms. Pavlon's doesn't keep a journal. Probably because she's staying with Mr. Pahl. She's with him all the time since she's helping him with his foot injury. The defense made a really big deal about that date of August 8th when Ms. Pavlon's came in with her pants wet. So let's talk about that day. We know that his truck returns at 2:34 p.m. Mr. Pahl walks in 4 minutes later at 2:38 p.m. Mr. Pahl exits and leaves the door ajar at 3 p.m. At 3:01 p.m., Ms. Pavlon's walks in and her pants are wet. So for 30 minutes, Mr. Pahl had Ms. Pavlon sit in the car with her wet pants. He's humiliating her. He's embarrassing her. He's controlling her. Then at 3:27, he has the gall to send her a text message that says, "Your piss stain," along with a picture of the seat. How condescending, how degrading. Her partner of 23 years. So what can make someone lose their bladder? Dr. Hale told you, strangulation, suffocation. Within a matter of seconds, when someone's being strangled, they can lose their bladder. So either that day at OAW, maybe even in the parking lot, they get into an argument. He's really pissed at her. He's upset. He wants to let her have it. He grabs her neck. He strangles her. She's terrified. Terrified. She begins to lose consciousness, and then she loses her bladder. See, strangulation's all about power. It's all about power and control. Mr. Pahl is showing Stephanie that he holds the power. He's in control, not her. She doesn't get to make decisions. He does. He holds her life in his hands. Then, in another act of power and control, he makes her sit in the car. After he's done this to her, after she loses her bladder, he changes his shirt. He takes his time getting back down there to let her in because she's stuck. She can't get into the apartment without him. She knows that. He knows that. He knows that she is at his beck and call. She is completely reliant on Mr. Pahl. Between August 19th and August 23rd, we know that Stephanie and Sherlyn had been communicating. We saw from those messages with Sherlyn that made Mr. Pahl really angry. So angry that he stops communicating with Sherlyn altogether. He stops communicating with her via Skype, says, "I'm not getting into texting battles with you," and he only communicates via email. Again, just a little glimpse of his power and control over the women in his life. He's worried that Stephanie's going to ruin everything for him. Because like I said before, these girls in the Philippines, they don't know his whole life. He's told them selective details. They certainly don't know that he's living with a woman in his apartment. Yeah, Stephanie knows about these women. That's an element of the control. Mr. Pahl is rubbing that in her face. He's allowed to talk to these women. She's not. He's allowed to have girlfriends. She's not allowed to talk to anyone. This becomes a constant source of arguments, in addition to all the other little things that Mr. Pahl makes a big deal about. The other arguments that he starts, maybe about a missing pill or not having Ms. Pavlons do exactly what he wants when he wants. On August 23rd of 2022, Mr. Pahl and Ms. Pavlons leave the apartment. They go to Quick Trip. These arguments continue. It's just constant with Mr. Pahl. He's constantly badgering at her in her ear. He goes into his appointment, and while he's in there, Stephanie is just stewing. She's like, I am sick of this. I'm done. I'm done with the violence. I'm done with the abuse. I don't want this anymore. I'm done with the controlling, manipulative behavior. She's ready to make a big change in her life. She's ready. It's not suicide. She's ready to dump the man that has abused her verbally, emotionally, and physically. By the end of that hour appointment, she's made up her mind. She's done. She's walking away. She doesn't want to be with him anymore. So she writes that note that's found in the car. And ladies and gentlemen, this note, this isn't a suicide note. She says, I hate you. I hate being with you. All you care about is yourself. I'm not allowed to speak my mind around you, drive, spend money, or even feel good. Karma came back to you because your foot injury, not me. Go be with your virgin because I'm done, and keep the fucking money. That's not a suicide note. That's a breakup note. That's an I'm done with you, goodbye, get out of here, I never want to see you again. So she writes this note, she leaves it on the driver's seat, and she's running out of time. She's got to get out of there. His appointment's almost over. He's going to be done with his appointment. She has to find a way out. So she gets out of the car, and she starts to walk away. She's like, I gotta be away from him. She knows she can't go into OAW, wait for her mom. That will definitely end in disaster. He sees her there and she's not in the car. You can guarantee he's yanking her out of there, taking her back into the car. She can't wait for her mom. She can't walk away. She can't walk down Gulf Road. He'll definitely come after her. He'll find her. He'll make her life even more miserable. So what does she do? She can't just sit there any longer. So she decides to walk towards that wooded area. She's probably thinking, hey, maybe I can go into the woods for some cover. Maybe I can walk over to a subdivision, call my mom. Maybe I can get to the golf course, call my mom. I just got to get out of sight. He can't see me leaving. But Mr. Pahl comes out of the appointment. She's run out of time. He sees her. He sees that she's not in the truck. He sees the note. It doesn't take very long to read this note. He reads it, and oh boy, he's mad. He's furious. He gets in his truck, he drives, and he sees Stephanie. He drives up to that little curve in the driveway. He sees her walking towards that wooded area, and he goes after her. He gets out of the truck. He comes after her. He grabs her by the back of the shirt. That shirt's too big. He's pulling the shirt up at her neck. And there's a struggle just outside the area of the woods. Maybe Miss Pavlons is vaping. During that struggle, she drops her vape. Mr. Pahl continues to grab at her shirt. He's not letting her go. And then what happens? Mr. Pahl grabs her purse, And ladies and gentlemen, this is the murder weapon. He wraps this around her neck. He strangles her for just a minute or two. That's all it takes. She goes unconscious, and she's dead. He uses the strap of her own purse to kill her.
Okay,
See, Mr. Pahl, he couldn't let Miss Pavlons have the control. He couldn't let her walk away. He couldn't let her leave him. He's the man. She does what he wants, not the other way around. He couldn't let her walk away. Only he gets to decide when this relationship is done. And in the ultimate act of control, he takes her life from her. He drags her body just inside the wooded area. The purse strap has caused a ligature mark, a little bit of an abrasion, a scrape to her neck, a laceration. That's consistent with the evidence, that there's some blood on the neck of her shirt, that there's a lot of insect activity at her neck, down to her collarbone, all the way to the top of her head. It's also consistent with the evidence. Look at the way her body is positioned. Look at the way her arm is stuck in her shirt. As he's grabbing her by the shirt, she's struggling. She's trying to get away. Her arms are up by her ears. She's trying to get her arm out of her shirt. She's fighting for her life. And Mr. Pahl takes her life from her. He doesn't know how quickly her body's going to be found. He notices that there's an injury. He panics. He drops the scalpel right outside the woods, right where that struggle started, thinking, oh, maybe I can say this was a suicide. He leaves Stephanie to decompose and be eaten by insects, effectively hiding any evidence that we have, effectively making it very difficult for the medical examiner to provide a cause of death here. His actions and his actions alone are the reason that there's no DNA, no evidence of injury, and that's because of her advanced stage of decomposition. So what does he do next? He grabs the purse, he grabs the water bottle, he goes right to his truck, opens the bed of his truck, puts the purse and the water bottle in the bed of his truck, drives off, goes home. See, he didn't realize that by just being next to Stephanie at the time that she's deceased, and by using her purse, there could be a little bit of tissue left on the strap of the purse. That tissue decomposes. That tissue causes that odor that Canine Raven is trained to hit on. He returns to the apartment with her phone. He goes inside and he brings his water bottle in. The purse remains in the vehicle. From 10:33 to 10:53 a.m., that's plenty of time for Mr. Pahl to have killed Stephanie Pavlons. It takes just a minute or two to kill someone by strangulation. Not very long. Not very long at all. It's plenty of time to kill her, and when he gets back to the apartment, he goes about his life as if nothing has ever happened. When he comes inside the first time, he just brings in the water bottle. And he thinks, oh, I don't need to conceal this. I know I've carried this before. But he knows if he carries that purse in, that's going to look suspicious. So an hour and a half later, he comes back down. He brings the purse inside at 12:29. That purse has been inside his car since 10:53. Enough time for that odor of a decomposing human remains to be just at the tailgate, just at the bed of the truck, right where Raven hits. He puts the purse in a Walmart bag to try and conceal the purse, so we can't say that that's what comes into the apartment. But he doesn't do a good enough job, because we catch that. Detective Seitz, right away when he reviews the video, catches that. When he brings the purse in, he cleans it off, he puts it on a shelf, and then has this theory. Oh, I'm just going to say she walked off. I brought it back inside with me. I didn't know if she was going to come back. The evidence suggests otherwise. Over the next days and weeks, he uses Stephanie's phone. He searches her name because he's trying to cover his tracks. He's trying to figure out what law enforcement knows. Mr. Wolf said, well, she wasn't answering her messages. Yeah, she wasn't answering her messages because he had her phone. He knew that. She's very private because Mr. Pahl has isolated her. He brings in the purse on August 23rd. The defense doesn't dispute that he brings in the purse. That's exactly what happened. The defense said in their closing that they had 3 questions. How did she get from the cab of his truck to the wooded area? That, what I just told you, that explains it all. He didn't carry her. He had to drag her a short distance. He was certainly capable of doing that. His foot injury did not stop him from getting rid of the one person that had the ability to ruin everything for him. Because if Stephanie left and she got a hold of Sherlyn, she could unravel his whole fantasy life. He couldn't let her go. He couldn't let her ruin everything. He uses her Facebook account. He wants to be ready when the police come. He was ready with a story. He just wasn't as smart as the police. Ladies and gentlemen, the evidence is absolutely circumstantial, but it's overwhelming. The only reasonable explanation supported by all of the evidence is that Mr. Pahl was a violent and abusive partner. He kills Mrs. Pavlons because she was trying to leave him, something he certainly couldn't let happen. Everything that happens after 10:54 on August 23rd of 2022 demonstrates that this wasn't a suicide, this wasn't a seizure, this wasn't an accidental overdose, an intentional overdose. No, ladies and gentlemen, this was first-degree intentional homicide. Mr. Pahl caused the death of Miss Pavlons, and he concealed her body. I ask that you find the defendant guilty of both counts.
All right, thank you.
Wow. I didn't like that as much. Another 19 minutes on the clock there for them, so they end up using about an hour and 10 minutes.
You are to decide this case fairly and impartially, without fear or favor, and without passion or prejudice. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 4 forms of verdict will be submitted to you concerning the charges against the defendant Matthew E. Pahl. As to count 1 reading, we the jury find the defendant Matthew E. Pahl guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant Matthew E. Pahl not guilty of first-degree intentional homicide as charged in count 1 of the information. As to count 2, another reading, we the jury find the defendant Matthew E. Pahl guilty of hiding a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant Matthew E. Pahl not guilty of hiding a corpse as charged in count 2 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may be legally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you're deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of the trial, it is important that you communicate with the court only by written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you're waiting for the answer. The court will answer any questions in writing or orally here in open court. When you've agreed upon your verdict, have it signed and dated by the person you've selected to preside. After you reach a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with the verdict. Ladies and gentlemen, at this juncture, we are going to swear in our bailiff, and then after that, I'll advise you of the two alternate jurors who will be excused, and I'll ask you to follow Mike's directions. Alternate, even though you are alternates, please don't discuss with anyone. We'll tell you that if you're welcome to stay, whoever you are, to wait to see if there's a verdict, or you can let the bailiff know and we'll either call you or let you know the results, or you can be here by phone when the verdict comes back. So if you can swear in the bailiff, please.
Do you swear that you will
Swear
keep
at
the
the
jurors
bailiff.
sworn on this trial in a quiet and convenient place? You will
We're going to end the poll here in just a minute.
except upon order of the court. That you will not report to any person the state or result of their deliberation until they have agreed upon a verdict, return to the court, and record it. So help you God.
I do. All right, sir, here's the jury instructions and verdict forms. And alternates are, I'm going to ask when I read your name to raise your hand. Diane.
I'm going to mute those. We don't want these names.
Folks, again, thank you so much. I know this is a disconcerting moment when you're all of a sudden separated from everyone you spent a number of days with. I assure you we thank you and respect the time you've spent. It's not wasted because it's important to have the alternates, and I appreciate that. Anything from the state before I release the jurors?
No, Judge.
Anything from the defense?
No, Your Honor.
All right, very good. You can go with Mike and follow his directions, please.
All right, as the jury leaves, let me just wax a little eloquent here for a minute. We're going to start the deliberation here, the deliberation timer. I want to tell you my thoughts on the closing there, especially the second one. Doors closed, starting the timer. There we go.
All right, the jurors have left. Have a seat, everybody. Anything before we stand down from the state?
No, Judge.
Anything from the defense?
No, Your Honor.
Okay, very good. Then, folks, please stay in the vicinity. This has been a long trial, and I expect there may very well be some questions from the jurors, at least about what evidence they may see. So please remain in the area and report to our clerk with your cell phone numbers. Okay. All right. Let's stand down. Thank you.
All right. As they stand down, we're going to keep monitoring this. But let's see. 4 is going to be 4. How about that? There we go. Keep the timer going. Let me tell you where I feel on this. I struggled with the second closing by the state, that rebuttal. And the reason I struggled is because in my head, I had built a scenario that was different than the one the state presented. I realized that they put together a story that could fit the facts. But in this case, the jury, in order to reach a guilty verdict, the jury they're standing at the side of a river. Okay, the jury's there. For them to reach a guilty verdict, they have to reach the other side of the river with dry feet. There are islands of evidence that they can hop from, but some of those islands are spaced out, and the prosecution has to build bridges between these islands. And in the closing, I mean, yes, the state built all the bridges, but in the second closing, instead of focusing on the islands of evidence, they focused on the bridges they built that could be designed a myriad of different ways. And I think they should have stuck to the evidence a little bit better on that closing, or at least said this could have happened. Now, I realize they don't want to say could have because that's introducing a possibility in the eyes of the jury. But just leaving the way they had it, I think they were better off in their argument before they did their closing than after. Because the jury having to believe this story that something like, whoa, she was strangled with a purse? And all this time you didn't tell us about that? All this time you didn't let us know that that was the murder weapon? It was like watching The Sixth Sense or something, and suddenly there's a surprise ending. You're like, whoa, didn't see that coming. The jury should not feel that way right as you send them off to say, how was the movie? I think the surprise ending, it works great for movies and books and things like that, but here the jury is like, whoa, they're deer in the headlights. Like, I did not expect that. And now you expect me also to believe that. Well, you did nothing to build that up. You did nothing to build up that scenario, to put the pieces together to say, here's the narrative as we believe it. You didn't ask questions about the purse strap, and is it, its strength, is it something that could strangle somebody? You didn't ask all the questions that would have sort of planted the seed in the mind of the juror, right? It's like, oh, I see where they're going with this. And then as they're building their own story in their head and seeing how things fit together, letting the juror complete those bridges instead of the state. Yeah, it works. It works. There's no piece of evidence I can think of that says, that doesn't fit with this story. But the whole when he comes out and sees her and she's getting out and she's vaping and everything, you're trying to put little pieces of evidence, but you've got this very elaborate story in there. And I didn't like it. I hope the jury can discount that story and just do their job based on the evidence they received. Because this was not evidence. This was not evidence, right? We could all present a theory of how we thought this happened. I mean, some people said, I think she went into the woods to use the bathroom. Some people thought, I think he did kill her in the car and moved out. In my head, I was thinking, what's the possibility that he went back to the crime scene to get something he forgot? And that's why we have the decomposition on the backside of the truck. That for me is a lot easier than the purse was in the back. We don't know it was in the back. I don't know. There was some decomposing flesh on the strap of the purse. It wasn't decomposing at the time. It was just like skin. But the contact then decomposed and created that. That was a stretch for me. It was a stretch. I think with his monitoring of the police and his interest in that area, I think it would be more likely that he went back to check and see if the body was still there or if the police had picked it up. That for me is more likely, even though there's no evidence. But now I have to try to piece this together differently. 6 minutes in. There should have been more setup, I think. Purse strap swabbed for blood. I don't think they did. There would have been blood on leather, especially on untreated leather. If it's on the inside, it would have been. I'm not sure if that's a treated side. Is it a one side treated or both sides on the strap? It might be a both sides treated. That would be more difficult. But if one side was untreated, then definitely would have been blood soaked up into that. His actions afterwards are so guilty. They had a great case. Wasn't liking that finish. Strangulation doesn't make you bleed. I agree, Red Pen. And strangulation with a device that is so forceful that it literally tears the skin? Wouldn't that have damaged that little bone that they found intact? Wouldn't that have broken something? Wouldn't that be more typical? Wouldn't we have seen more? I wasn't going to go with strangulation on this one. I know it fits with the losing the bladder, but so does somebody just being scared of being hit. Can be the same. Anyway, the green scalpel. She did have green scalpels in her medical bag. But I'm not sure if she had it in the purse. Like the chain on the strap of the purse, there would have been some evidence there. Restraint, not strangulation. Look at the bag strap on the end. It looked like a metal chain. There is a bit of a metal chain on there up next to the bag. It's just a few inches, not enough to go around to the entire neck. And that would have probably caused more damage to the neck. Strangulation can make you bleed. Right, but I would think that would also then cause the other damage we see with the damage to that bone in the throat, that super sensitive bone. Scalpel is super weird. Did she use it to cut? I think it's more likely to me that he placed it there to make it look like it was something else. He could have hit her and caused internal bleeding in her head. That's it. She could have been bleeding from the ears and the head, nose, whatever it is, to get blood on her shirt, and left her. Because the body was so decomposed, we don't know. Would his skin be on it? Arguably, because they lived together, you could say that it would be expected that his DNA would be found on the purse as well. Could have done a chokehold with an arm, like an arm bar type thing. Doesn't always break. I hear that. The fact that we're all saying he could have. I hear this. Sorry, I know you pulled that one. I hear that. But I still feel that this being a circumstantial case, yes, without the other evidence, just finding her in the woods, it's likely, it's reasonable, I would say, that self-harm is the cause, or something else. Some diet of natural causes could even be there. Those would be reasonable. But for me, that's not reasonable doubt. When you take in the totality of the evidence, when you take in all of his actions that are highly, highly suspicious and incriminating, I would say, his behavior, his guilty knowledge, his guilty behavior, his searches online, everything. It takes that away. It takes it was just normal thing happened and she died on act. It takes that away from me. So I'm beyond reasonable doubt on that. I believe he did it. I just don't think that it helped the state to try to lay out their version of events like that, especially ones that had so many jumps and skips to get through the evidence. There are 20 different ways you can hop through all the islands of evidence without building that story, and I don't think they needed to. Now, I realize they went for murder one, and the murder one has two elements, right? They have to say that he caused the death and that he acted with intent to kill, and that's a hard one for this case. I would say that's probably the hardest thing to prove. And if they come back as a not guilty, I think it will be on that second element that the state did not prove that he acted with intent to kill. It would be wild if this came back with a split verdict of guilty of hiding the body and not guilty of murder one, or vice versa, guilty of murder one and not guilty of hiding the body. So the danger of that wild story is the jury doesn't believe it. Do they throw out the evidence and vote not to convict? They didn't need that. Yeah. Hey, well, I do appreciate you holding us to account. Making sure we we hold the state to their burden. And I think the one thing I've learned in all our time that we've been together is that burden is higher than I thought it was before we started watching court together. That burden is higher. Beyond a reasonable doubt is an extremely high burden. They showed it in steps right there where each step was a little bit higher, a little bit higher. I think that last step is a massive climb, and you need help getting over it. I just don't think that it can, I don't think it can be an easy step to get to. Oh, hang on. Somebody's there. Just one second on the phone. Hello? Who is it? Oh, I think they hung up. They're gone. Try again. What was the results of the poll for how long the jury would be out? I missed it. Came back with, well, let me post it right here. Just one second. I've got all of them right here. 4 to 6 hours was the winner. But let's see if that, put it in chat right here. How long will the jury deliberate? 2 to 4 hours was 49%. 4 to 6 hours, 22. Okay, so 2 to 4 was the winner. 1 to 2 hours at 22%, and over 6 hours at 7%. Did I get your voicemail? Not yet, Sloth Life. I will have to check. I did not get that. Let's see. Mrs. R.A. came in. Without giving too much details, she's volunteering as a teacher for an intro to college education program to help people who maybe aren't ready to go to college, but with a little bit of help could get there and then could move forward. So it's a really cool program she's part of, but she found out she needed a computer, so because the iPad wasn't going to work, so she needed me to help her look for computers. That's why she was here. That's why we were looking over there. And she was watching chat as well, so she did say hi. Is there any chance of a retrial if he's proven guilty? Yes, there's always a chance of a retrial if proven guilty because he has his appeals. And red pen. Yep. Well, if you want to talk to her, I'm sure she'd love to. Probably not on the air on this one. Was there any evidence that Stephanie went with him to his other appointments? Was that ever discussed? Yes, I think there was some evidence that way. Wish there was a fun trial. Would that be a civil trial? Let's see. Sorry, is the cat's pajamas. She's amazing. Love her. No on the civil trial, says Little B. Do we have any palate cleansers lined up? We don't right now. We're just in a holding pattern. Let's see. She went where he did. He never left her apartment. The abuser and the victim. The relationship was quite clearly defined in this relationship with Stephanie, depending on Matthew for everything. Stephanie was being treated by a doctor who said, I can see your condition. I see what you're suffering from. This is what you need. And Matthew was in between that, forcing her through physical abuse or threats or otherwise to surrender all of her drugs to him. He's convinced her that she cannot do this herself, and he is the one that has to make sure that she does this correctly. And so she depended on him, and she was constantly in a state of either extreme pain because she wasn't getting enough meds to take care of the pain, or just that the needing. She was an addict, okay? That she needed more than she was getting, and yet she had to go to him and through him to get it. And if she ever tried or did manage to take her dose, right? She took one of her pills and got beat up for it. I think that was very clear that whole scenario was terrible. And I do think that note is is a "I'm leaving you" note, which makes it the most dangerous time for sure. Let's see. Is there a podcast on Thursday? Yes, Thursday. I've been following a civil case of the teacher shot by the 6-year-old student. It's a tricky one. Yes, that's happening in Virginia. We may be trying to line up the criminal side of that one, not the civil side. We're looking at what we can do there. Let's see. Maybe he threw the purse in the back of the truck. We'll never know. The evidence still points to him. You know, it's also possible that the dog did a false alert. I mean, 80% of the time, that means 1 out of every, 2 out of every 5? 1 out of every 5 times, the dog doesn't get it right. There could have been no decomposition on the truck. For me, that wasn't the smoking gun. It wasn't the smoking gun. Let's see. Josh says, I've got something on Mod Chat if we're interested. We are interested. We always are interested in a little palate cleanser. Let's see. See if we can find this one for you. Get a palate cleanser lens up. See if we can get, sorry about this. Let's see, Diego, is this the right one? Got it.
Back on the record. Mr. Rowley, how did your client want to proceed?
Your Honor, my client will accept the offer of a disorder that was received.
Okay, advice and rights, please.
We have not completed that yet.
Oh, yes.
It's mini court. Is a small courtroom.
Yeah, but
Did we get this right? Oh, I'm at the wrong one. I got to move it back here. Sorry.
On the record, in the matter of the people of the state of Michigan versus Portia Savage, 25-02183. Appearance, please.
Jeffrey Billabay on behalf of the people, Your Honor. Jacob Rowley on behalf of Ms. Savage.
This is the right one, Josh? At the very beginning, you said, right?
He's entering the courtroom now.
She's not here?
But am I having an out-of-body experience, Mr. Rowley? Have you met with your client today?
I have, Your Honor.
Have you talked to your client about how to appear appropriately in court?
Your Honor, she didn't say health concerns.
What has that got to do with a hoodie and a hat on her head? In the middle of my courtroom. Are your witnesses here?
Yes, Your Honor.
You're having a trial today, correct?
We have pitched an offer, so we were just waiting to hear.
We don't do offers on the day of trial in my courtroom. That's been my policy, and the attorneys here and my staff are very much aware. We had a final pretrial on the 22nd of September, to which your office represented that the victim was here.
Correct, Your Honor.
And so if there was no offer extended at that time, the time to negotiate is now over. Today is the date and time set for trial. are we running a trial or no? Or is she pleading to the charge?
She's, I would leave that to defense. She's not pleading to the charge, Your Honor.
Okay, you can call on the jury.
Thank you, Your Honor.
You will bring the jury.
I don't have jury instructions. They were supposed to be to us by Friday, 3 p.m.
That is correct, Your Honor. I couldn't reach the victim. I tried to contact her on Friday. She did not pick up the phone. I left a message. So we showed up today thinking she wasn't going to be able to show up simply because I couldn't consult her or give her any offers prior to this date, Your Honor.
You had a final pretrial. You
Correct.
said that the victim appeared.
Yes, at the final pretrial, the victim did appear, Your Honor.
Well, what does that got to do with my jury instructions that were supposed to be to me by Friday?
I apologize, Your Honor.
What's your jury instructions, Mr. Raleigh?
I have them prepared. I can forward them to the court, Your Honor.
I need them within the next 20 minutes.
Yes, Your Honor.
And I don't know when you're going to do it because we're running the rest of this docket right now.
Yes, Your Honor.
Your client can go figure out how she can be appropriately. You need to take your hood and your hat off now. You can't dress like that in court. Ma'am. I'm sorry? I can't even identify who this person is. Her entire face is covered, Mr. Raleigh.
Yes, Your Honor.
Take your hood and hat off so I can identify you. And whatever's on your head, take it off.
I've already made it.
You have one choice: to do what I say, or you be held in contempt. You still have things on your head. I can't even see your face.
Ma'am, I would like to protect my.
You can remand her into custody.
That's the only reason why I'm asking you. I've already made it clear on multiple accounts that I have vaginal problems, and I'm also health concerned because.
What does that got to do with? I have to be able to see your face. What does that have to do with that? I can't see your face. I'm not going to go back and forth. I'm not going to negotiate. There's rules and there's policies. If you can't follow them, you'll be held in contempt and you'll be remanded into custody. You can remove the items or you can be remanded into custody. It's your choice.
How long are we discussing?
Until I can have the contempt hearing. Because you're not going to sit in a trial like that either.
But I don't want to take my mask off in front of other people.
Take your hat. Whatever's on your head needs to come off. You don't wear do-rags in court. Take it off your head now. Remove your face mask so I can identify you. I need to see your entire face. I can't see your face. I can take her into custody. I don't have time for this. You'll have a bigger issue sitting down in jail.
How long am I? Yeah, I've already taken the mask off.
Oh, no, you didn't. No, you didn't. I cannot see your face. And I'm not going to go back and forth. Thank you. You remove it down lower so that I can identify you. When I said I've identified you, then I will allow you to put your mask back on. Not only that, you look at me when I'm talking. There's going to be a portion during this trial where you need to be identified. You'll be ordered to remove your mask again then. Your attorney should have told you that.
Wow.
You can have a seat out there and wait until it's time for us to call you in for jury selection. Mr. Raleigh, you need to talk to your client because my patience is very short already with her.
Yes, ma'am.
You understand?
I understand.
Okay. On the record in the matter of the people of the state of.
Okay, so now we're going to fast forward to see.
On the record on the matter of the people of the state of Michigan versus Augie Green 25-01600.
Jeffrey Billabay on behalf of the people, Your Honor.
Good morning,
Your Honor. Assistant Public Defender Lawrence Sutter.
Let's go forward and see how this one concludes here. I think it's about 48. Josh said 47:34. Oh, hang on. A little before then. Here we go. Coming back. Of course, it's Michigan, says Jedi Jet. Corey May. Corey May, what's your son's name? Let's see. Let me see. Hang on. Let's see. I think I missed a message here. Can you please shout out our son, Cruz, listening after school in the car together? Thank you very much, Corey. Cruz, hopefully I didn't miss that. Hopefully your ride home is still going on. I'm not sure why I've got the snorkels. Are you a snorkeler? I see the boat. Okay, so you're a water family. That's cool. Cruz.
Ma'am, what is your problem?
Your dad's cool.
Ma'am, what is the problem? I can't even hear you. I cannot hear you. I cannot hear you. No, you don't. Then don't be disrespectful. You don't run my courtroom, I run it. You're going to come in here, I'm going to go on the record properly, and you're going to present yourself appropriately.
Alexis.
And not with a rag hanging off your head.
9 months.
This is actually all that I have right now.
But you can take
On
it
the
off your
jury.
head. I'm not asking you to remove your mask. I've identified you. You can keep the mask on. Okay, back on the record.
Jeffrey Billaby on behalf of the people, Your Honor.
Wow.
Jacob Brown on behalf of the Saboteur.
Today was the date that was scheduled on my docket to hold a jury trial. The attorneys were both advised of the policy in this court. It's the 54A district court policy, which is we need to be notified by 3 p.m. on Friday whether or not a jury is going to be called in. And there's a reason for that policy. Mr. Billaby, you asked me if I could extend the policy on Friday. I told you no, because it's not even my policy. It's the court's policy.
That is correct, Your Honor.
And so our staff did not get anything from either attorneys, one way or the other, indicating whether or not there was going to be a jury trial. Therefore, that information was not properly provided to administration, and they call in a jury on Friday. They don't call it in on Monday morning.
Yes, Your Honor.
And so we brought a witness in here for no reason, because we can't call a jury in. And that's because of the attorney's failure and not the court.
I understand.
And I want to make that very clear. Was there an offer that you intended to extend today?
Yes, Your Honor. In consultation with the victim and my unit chief, we extended an offer of disorderly, and I understand that is not what the court's policy is. Before I get to that, Your Honor, I just want to sincerely apologize.
Ma'am,
for putting...
wait a minute, ma'am. Take that off your face.
Just covering her eyes.
Excuse me?
I'm saying I'm very sorry. I just don't feel well at all.
I can recognize that, but you can't cover up your face while you're standing in court. I'll allow you to cover your mouth and your nose for your health, but you're not going to cover your entire face, okay? Okay.
Your Honor, I just want to sincerely say I sincerely apologize for mishandling this matter, and I understand that puts the court in a very difficult position because now we're having to call a jury. I did attempt to reach out to the victim on Friday. She informed me that she tried to reach back to me. I didn't get that. And obviously I wasn't anticipating there would be a jury trial here today. Either way, Your Honor, I accept my failure to be able to promptly inform the court timely whether this, to set a jury trial. And it's a policy that the court has made very clear to me. And so I want to apologize on that, Your Honor. The offer in this case, I had a discussion. I talked to the victim and in consultation with my unit chief. Today, we offered a disorderly person. This offer is agreeable to the victim and to the unit chief. And that's what we offered here today, Your Honor. And this is the first time I've had really any opportunity to consult with the victim during the entire duration of this case. This was my first time seeing her and even talking to her in person, Your Honor.
Did the victim appear on September 22nd?
Yes, Your Honor, but that was with a different prosecutor. She appeared on the final pre-trial, and she did indicate that the case will be set for jury trial according to our notes, Your Honor.
Correct. Negotiations in my courtroom happened prior to. And so if the victim appeared on the 22nd, whether it was you, Mr. Billaby, or someone in your stead, because I recognize it's not your fault that you just got subbed into this courtroom, but you put the court in a position, your office that is, when you keep changing the attorneys, there's no consistency going on. Whoever is here should have extended an offer if an offer was viable at the time. If there could have been an offer extended, it should have happened then. That's the point of the final pretrial, okay?
That is correct, Your
And so
Honor.
that's a message you can take back to your staff or to your office so that they know, I don't care who is in this courtroom, if the victim is here for final pretrial, what do you think we're all coming here for? A kumbaya moment? It's to try to work out the matter and see if we need to go to trial. Once I set a trial date, it requires all of us to be here. And it requires people to move their work schedule. You didn't think the victim had someplace she needed to be today?
She did, Your Honor.
I had personal things going on that I had to rearrange so that I could be here in person so that no trials were being reset, only to get here and not to have a trial. Ma'am, are you okay? Okay. And so, Mr. Raleigh, there's an offer of disorderly person. And then Mr. Bilby, I accept your apology. And I recognize that part of this is not your issue. It was a change in prosecutor office. Nonetheless, is she going to accept the offer?
I would say yes.
Either accept the offer today, and it's accepted as a plea.
If you need more time to talk to her, I could give you time to do that.
Or we set it for. If we can have a moment, Your Honor.
No problem. Off the record.
Thank you, Your Honor.
We'll give him a minute here. We do have a little bit of a throwback to do as well while we wait for the jury to do its work in this Wisconsin case, this other Wisconsin case, because Sarah Boone did write another letter, and I think it needs to be read. So we will add that to the list of what to do here during the break. I think we can fast forward through some of this. I'm not sure when they come back in.
Back on the record.
Okay, perfect timing.
Mr. Raleigh, how did your client want to proceed?
Your Honor, my client will accept the offer of disorder that was received today.
Advice of rights, please.
We have not completed that yet.
Oh, yes.
All right, I think that's pretty much done. So this is the resolution.
Yeah.
I think she learned a lesson. Wearing 4 hats and 2 masks in court is not acceptable in Wisconsin. Hoodie, baseball hat, cap, and bandana, and 2 face masks was just, I think it was one too many in this court. So we will we'll go back to right here. All right, let's see. We have a letter to read, and in doing that, I sort of have to. Where can I send this? Oh, I was Michigan, right? This is Michigan and not Wisconsin. I'm sorry, MIWI. The letter's upside down. What's it called when you're dyslexic? Top to bottom. I don't think that's a thing, is it? All right, let's read the letter, but I want to get it on the screen for you, so if you can hold on for just a second. Let's get this set up so you can read this. This is another handwritten letter, and I think it'll work like this. Can you see this? Does it work for y'all? All right, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, State of Florida, plaintiff v. Sarah Boone, defendant, notice of inquiry. Comes now, appellant Sarah Boone. I'm going to make this just a tiny bit bigger because, my eyes are old. There we go. Comes now, appellant Sarah Boone, and files her notice of inquiry with both the 6th District Court of Appeal and Orange County Clerk of Court, stating the following in support of 1. After appellant's first court-appointed appellate attorney, Alan Holland, December 2nd, 2024 to February 18th, 2025, was granted his motion to withdraw, Joshua E. Adams was appointed by the court to represent her and submit the initial brief in and for her criminal appeal. During Mr. Adams' tentative time frame of 7 months, February 18th, 2025 to September 5th, 2025, in his representation of Ms. Boone, which includes filing two extensions to continue doing so, he made the decision to withdraw without submitting her initial brief, citing he is no longer practicing appellate work or accepting court-appointed appellate cases. He's like, I'm out. This is crap. This is crap. Joshua E. Adams corresponded with appellant in one public access tablet message on February 27th, 2025, briefly introduced himself with no follow-up or continued contact to present date. 4. As of the date of this filing, appellant has no understanding of whom her present appellate attorney is. The current status... Sorry, I can't do it that way. The current status of her appeal, nor the preparation of her initial brief as a result of no communication or inclusion from any party, including both the 6th District Court of Appeal and or the Orange County Clerk of Court. Wherefore, appellant Sarah Boone respectfully files this notice of inquiry to request the pertinent information regarding the updated name, contact phone, and address of the successor court-appointed counsel to represent her, and the status of her appeal, including the filing of the initial brief in this matter, submitted this day, 27th day of October, 2025. Signed, Sarah Boone, with her address in the Lowell Correctional Annex on Gainesville Road in Ocala, Florida. There we go. Whew. All right. I will say this. She's a handful. She's literally driven people to quit the practice of law, I think, at least certain aspects in the practice of law. And as a result, if I can get this pulled up correctly, she's struggling to have somebody do the necessary work for her to get her appeal filed. Well, okay, 4 is going to be 4. Oh, we got the timer back. She has a legitimate complaint. As terrible as she is to work with, she has not done anything that we know of that has caused the attorney not to want to work with her. She's just difficult to work with. And she deserves to have a lawyer. She should have a lawyer that files her initial brief with the court to appeal. I don't know what the deadline was. I thought it was like 60 to 90 days after her sentence. It wasn't very long. It could have been as much as 6 months, but I don't think so. And they've blown past that timeline, and no notice of appeal has been filed on her behalf. But she needs to have a lawyer that will do that for her. And heaven help that lawyer. You are going to have all the inherited, generationally, 70 days, says Peter. Awesome. Amber says, haha, she made him switch sides. Ha, he quit the public defender office in September 2025 and accepted a position with the DA's office. He's like, no, I'm not going to defend people anymore. I've seen what they're like. It's an O sound in Lowell. She needs somebody. And until she gets somebody who's willing to do it and stick with the job, I think the extensions will keep getting granted. And I don't think it would be constitutionally fair for her to lose the right to appeal her conviction because her lawyer wouldn't do the work, right? Yeah, I think just common sense will tell you that, even if she's just terrible to work with. But it's possible that we can have the current judge in this case, who is, let's see, Michael Kranick, make it similar findings we had previously, where Sarah Boone has done enough to cause lawyers to quit that she has elected to lose the right to a court-appointed attorney for that purpose. But it's going to be. It would have to be pretty egregious and more than what we have here. So, but it was not intentional. Yeah. All right. We've got another letter here. What's this? This is the motion to withdraw as counsel. I think that's basically what we just covered. Just reading this, this was filed, let's see, what was the date on this one? 9/8/2025. Motion to withdraw as counsel comes now. Rodrigo M. Caraco, I think, and moves this court to allow him to withdraw from representation of the defendant Sarah Boone, and as grounds therefore states, the court appointed counsel to this case on September 5th, 2025. However, undersigned counsel has accepted a position within the Office of the Attorney General's Office of Statewide Prosecution effective September 12th. Consequently, undersigned counsel is winding down counsel's criminal practice and has resigned from the court-appointed registry. That's where you get, you're on the list for the judge to hand you public defender cases. Because the defendant's case cannot reasonably be resolved prior to September 12th, undersigned counsel must withdraw from the further representation pursuant to Florida Bar 4-1.7. Conflict of interest. Undersigned counsel has not previously filed a notice of appearance. So he was just assigned and then released, right? Because he was assigned on September 5th and then released. Let's see, January, February, March, April, May, June, July, August, September. So it was a few days later. He was only on for a little while. I had to count on my hands to figure that out. I'm terrible with months and numbers. I wonder if Donna Adelson has met Sarah Boone. Are they in the same prison? I don't know. I doubt if they're in the same place. All right. Let's see. Who says pause? Express bus is the safest way to travel in the city. I can put my swivel on pause for an hour. Oh, like your head on a swivel, watching your back, Tash. Okay, I got it. Pause your swivel. Let's see. It's really amazing how people can completely miss social cues. I've been guilty of that myself a time or two. All right, what do we do now? It is 5 o'clock. Let me tell you what I have on the schedule tonight. I don't think the jury's going to reach a verdict tonight. I really don't. And it's Pickles, not politics on this channel. But tonight I have to go vote in my local election so that I can have the person who represents me at the town level be better than the last person who represented me at the town level. So I have to go vote. So otherwise I can't complain for another however many years they sit in office and do all that. So I need to go vote in my local town thing. If you have one of those things, I recommend you do it as well. Are we going by beast now? I think we have to end, but I want to have it set up in case there's a verdict. We can come flying back here. It only takes me like 10 minutes to vote, I think. Maybe 15 minutes if there's a line. But yeah, go out and vote. Vote for the liar of your choice, but vote. That's what I recommend. So, all right. Anything else we need to cover before we continue? I think what's going to happen here in court is we're going to have questions from the jury first, probably about evidence, and then we're going to have a verdict maybe tomorrow at the soonest. That's my call. So, or what could probably happen is we'll get a verdict right now because we're saying we're going to call it quits. It's only 4:06 p.m. in Wisconsin. They could have a verdict today. They could, which is why I need to vote right now because my ballot box closes in 2.5 hours. So I need to get there. Does Wisconsin let them go late? It's up to the court, Katie Bug, and the judge. And when I say court, we're talking about generally the bailiffs and the security and building people, like the people that have to be in the courthouse for the building lights to be on and the air conditioners to run and the bathrooms to be cleaned and stocked and all that. Those are the people that are really crucial about whether or not we'll be okay. We're gonna wrap it up then. I'm gonna go vote. We've got time. Have we discussed another Canton police officers on administrative leave? We have not, but that sounds good. Just kidding. I think it was Officer Good or Lieutenant Good or something like that, who is on leave investigation. There it is. Goody. Goody, goody, goody. Music, please, says Carol. All right, we'll do the music. We'll do it. Yes, they can go late. It's the leaf blower guy. Hello. I can leave chat up. I can do this. I could leave the I would leave it like this. Ready? You'd just be watching my office. Does that work? I'm just going to go vote, and then we'll come back and talk and see what happens. I'll take my phone with me, so if something happens, you guys can reach out to me on the burner. Red Pen says no. RA is not leaving chat up. I give 10 memberships to not leave it up. I was going to say, you want to go vote too? Okay. That means you volunteer the mods to monitor chat. The mods are rebelling. Hide the candy ball. I tell you what, we've been live for 3 hours and 21 minutes. We'll go ahead and wrap this one up, and then if something else happens, we'll bring it back. We'll start again. Which means you should just be subscribed to the channel. Click the bell to be notified when we go live again. And if there is a verdict tonight, we will go live and bring it to you. And that way my mods will still continue to help me out the way that I need them to. So, and they can vote as well. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again, either tomorrow morning if there's no verdict, or sooner if there is a verdict. Hit me up if you hear anything, if you hear any rumblings of a verdict on the burner phone. Guys, catch you later. Have a good night. Bye-bye.
Hello, hello.
In front of the Walmart.
Hello.